And please indicate, applicant in particular, if you will be reserving any time for rebuttals. Thank you. All right, I think we can commence with the applicant while the respondent is typing their names and their time allocations for us in the chat box. I see that they are typing. So applicant, we may hear from the first speaker. Before we do, can I please request that all other individuals who are in this session who have not renamed themselves appropriately do so now. Otherwise, I will have to take them out when we are in session, and I will take them out mid-session. So please indicate if you are supporting a team, whatever, have a team number by your name so that we know who you are, or have an official's key indications so that we know who you are. Otherwise, I will have to take you out of the session. We will be interjecting you during the session. I will be keeping track of your time, and so you will have to pay some attention on my side so that you know how much time you have left for each of you. And with all that being said, please, applicant, first order list, you may proceed.
As the court pleases, my name is Nsmcc. I appear as the first counsel for the applicants. I appear together with my co-counsel, Nonduduzo Tangazela. There are two issues that lie before this court. The first being the unconstitutionality of Section 4 of the Schools Code of Conduct, which is found to be violating our clients' rights to privacy and basic education in accordance to Section 14 and 29 of the Constitution. The second issue is that the SGP's decision is unconstitutional and violates our clients' rights to peaceful assembly in accordance to Section 17 of the Constitution. As the first counsel, I will be dealing with the first issue, arguing for 9 minutes. My co-counsel shall proceed and attend to the second issue, and she shall argue for 9 minutes, and we will save 2 minutes for rebuttal. Your Justices, counsel for the applicants request to bring the two following points before the court. The first point being that the Constitution of the Republic of South Africa is the supreme law of the country, as it is stated in Section 2 of the Constitution. This means that any law or rule that is found to be violating the Constitution must be amended to remove the unconstitutional parts or declared invalid. In order for us to ensure that decisions made by our courts are respected, Your Justices, I would like to refer you to the matter between MEC for Education versus Pillay, the case of 2007, number 51 and paragraph 6, where Sonali Pillay was the young Indian lady that used to wear a gold knot stud in respect to her religion. Now, I am aware that religion and education are distinguishable. However, the principle of case precedence still stands. Your Justices, I would like to refer you to the matter between Head of Departments, Department of Education, Free State Province versus Volcom High School, the case of 2014, number 228 and paragraph 58.
Counsel, before you continue, what is the principle in the Belay case that you would like us to take into account? And two, how does it relate to the facts of your case?
Thank you for your question, Your Justice. The principle that I was referring to is the principle of case precedence, which states that it is important to ensure justice and fairness, and for courts to avoid random decisions being made. So I was requesting for these courts to also consider this principle in relation to this case.
You may proceed, Counsel.
Thank you. Section 4 of the Schools Code of Conduct violated our client's right to privacy, which states that everyone has the right to privacy, which includes the right not to have A, their person or home searched, B, their property searched, C, their possession seized, or D, the privacy of their communications infringed. Your Justices, it is with respect that I submit that the whole world is moving towards fourth industrial revolution. The school must create mechanisms to integrate the use of cell phones at school. I humbly submit that learners should be encouraged to bring their cell phone to school in order for them to be able to record lessons in class and download material that might assist them get a better understanding of their schoolwork. However, this does not mean that discipline should not be enforced. Discipline can be enforced by instructing these learners to only use their cell phones for the purpose of teaching and learning, and for them to ensure that their cell phones are kept on silence at all times. Your Justices, I humbly submit that Section 8A of South African Schools Act provides for random search and seizure. However, it clearly states that the principal or his or her delegate may at random search a group of learners or the property of a group of learners for a dangerous object or illegal drug, but not a gadget like a cell phone. Therefore, it is an unreasonable suspicion that was established by the principal's order of Untitled Combined School. It has invaded our clients' privacy and has infringed their constitutional rights. Your Justices, I would like to outline the guidelines of search and seizure practices that states that searches are conducted after considering all relevant factors, such as A, the best interest of the learner in question, B, the safety and health of the learner in question, and C, reasonable evidence of illegal activities. However, it is important for any search to meet the reasonableness test. That is, it must be based on credible information and carried out in a reasonable and sensitive manner. It is said that whenever principals can, they should determine in advance whether a particular search is going to become the matter of the police and would they want the learner to face criminal charges or potential conviction. I humbly submit that our clients had just brought their cell phone to school and it is not a matter of the police. I humbly submit that education is central to every child's development. It is a key to a better life. It has been eloquently populated that education is a bridge from misery to hope. It is used as a tool in modern society and is a building block of all development.
Disturb you just a little bit there, tracing back from the argument that you just made now. I think we would all agree that, yes, the right to privacy is, the fundamental right that is protected in terms of the Constitution. But isn't that right, or the intensity of the protection of that right, diminished once a person is in public spaces, in public institutions? Because in those particular instances, we are dealing with public morale, and therefore we cannot really intensify the protection to the right to privacy.
Thank you for your question, Your Justice. However, I had submitted before that the Constitution is the Constitution of the Republic of South Africa is the supreme law of the country. That means that any law or rule that is found to be violating the rights in the Constitution must be amended to remove the unconstitutional parts. In this case, our client's rights.
I agree with you, but for example, this very court in Ministry versus Interim Medical Council of South Africa has previously stressed that the more you are undertaking in public activity, the more attenuated any corresponding claim to privacy in respect of an activity would be. And as that shows that even the right to privacy itself is not absolute. And in particular, whenever we are dealing with that right outside of personal private realms of an individual, once we are dealing with that right in public spaces, then that right is diminished. So for example, if a student has got a gun on them, which threatens the life and the safety of the entire school population, from the staff to the learners, would you not say it's justified that the student is searched and as a result that the gun is seized? Because what is the point of the search if they're not going to take the gun, for example?
Thank you for your question, Your Justice. I would like to refer you to the matter between Minister of Home Affairs versus Fori at paragraph 16, where it is stated that the states may not unfairly discriminate directly or indirectly. In this case, there is
discrimination in this case, because Fori was very particular. It was discrimination insofar as it dealt really with marriages and unions. So are you alleging that there has been discrimination in this case? On what ground then?
Thank you for your question, Your Justice. These learners have been discriminated against because in a set of facts, it is stated that Sifiso was given a chance to undergo disciplinary hearing, of which our clients were not given this opportunity because they were immediately suspended from school.
So they were discriminated on what ground? On what ground of discrimination? For example, Section 9, if I'm not mistaken, says a person may not be discriminated against on one or more of these grounds, and then it gives us the grounds. So on what ground would you say the learners were discriminated on?
Thank you. On the ground that everyone is equal before the law. So learners should be treated uniformly at the school. May I proceed?
Yes.
Thank you, Justice. Furthermore, Section 28, subsection 2, which is a child's rights, states that a child's best interests are of paramount importance in every matter concerning the child. We therefore humbly submit that in the set of facts, it is stated in paragraph 7 that these learners are between the ages of 14 and 17. They are still vulnerable and they still need protection and guidance of the law. I humbly submit that in the case between Federation of Governing Bodies versus South African Schools versus member of the Executive Council, the case of 2016, number 209, at paragraph 44, it is stated that public schools are not refined spaces only for the bright or mannered and financial well-heeled learners. They must not advance the parochial needs of immediate learners. So I humbly submit that our clients should not be suspended from school for the rest of the year, because the public school must be aimed at offering universal and non-discriminatory.
If I may quickly just disturb you a little bit there. Nowhere in the facts does it say that they are suspended for the rest of the year in respect of, insofar as we are dealing with the 6 applicants in this case. It says they have been suspended for the maximum period. In accordance with the South African Schools Act, suspension, the maximum period would be 7 days. So should we not assume that they have been suspended for 7 days instead?
Thank you for your question, Your Justice. However, the first suspension issued by the SGB was for them to be suspended from the rest of the year. And Section 9, if I may refer to
that was in respect of SFISO, but SFISO is not an applicant in this case, so we cannot hear anything about SFISO. You have about 10 seconds remaining, so perhaps address us on the last issue that you've got. Quickly, just summarize it.
Thank you for your question, Your Justice. However, it is these 6 learners that were suspended from the rest of the year, and not SFISO. And if I may refer you to South African Schools Act, Section 9, subsection 2, where it is stated that the sanction must be imposed on a learner, not to be punitive, but must be intended to rehabilitate the learners.
Thank you very much, counsel. We may now hear from the second counsel for the applicant.
If it may please the court's justices, for the sake of the record, my name is Nsmcc. I appear as the second counsel for the applicant in this matter. Since my learned co-counsel has dealt with the first issue, I will proceed on settling the second issue, that the SGB's code of conduct is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution, as well as the unconstitutionality of corporal punishment in terms of Section 10 of South African School Act number 84 of 1996. Justices, it is accurate to articulate that even the balancing test does not prove it right. Education has more value than cell phones being carried to a school that doesn't permit them. Therefore, I can confidently say that the school's code of conduct is unreasonable and unjustifiable according to all the evaluations done at Section 36 of the Constitution. Any law that is not in line with the Constitution is invalid. Justices, if I may refer you to the hypothetical case, paragraph 2, it is stated that the learners are punished even for small transgression and corporal punishment is enforced. It is my submission, Justices, Section 10, subsection 1 of South African School Act number 84 of 1996.
Counsel,
It states,
if I may allow me to redirect you to what this court would particularly be interested to hear about. I think we are more interested to hear, how is the suspension unlawful? How does it violate the students' rights to peaceful assembly in accordance with Section 17 of the Constitution?
Thank you, Justice. With respect, Counsel for Applicant submits that Counsel for Respondent must review South African School Act number 84 of 1996. Section 9, suspension and expulsion from public school. It states, subsection 1, a governing body may, on reasonable ground and as a precautionary measure, suspend a learner who is suspected of serious misconduct from attending school, but may only enforce such suspension after a learner has been granted a reasonable opportunity to make representations to it in relation to such suspension. Justices, if I may refer you to the hypothetical case, paragraph 6, it is stated that the 6 learners are suspended with immediate effect. It is our submission that our client's right to adhere to disciplinary proceeding was violated by the respondent, as it is stated in.
If I may, you make a very good argument there with respect to the right or the opportunity to make reasonable representations before suspension. However, is this still a requirement in terms of the South African Schools Act, where the school code of conduct is clear on the consequences of a breach of a provision in the school's code of conduct? In this case, we have the school's code of conduct, which specifically states out that if students are found to be in possession of a mobile cell phone, they will be confiscated and they will be suspended. In instances such as that, where the school code of conduct is clear on the consequences that must follow when we are dealing with a particular breach, is the governing body still expected to give the students the right to make representations in accordance with the South African Schools Act?
Yes, Justice. Thank you, Justice, for the question. The answer to your question is yes. According to subsection 1A of Act number 24 of 2005, it is stated that a governing body must conduct disciplinary proceedings in the manner contemplated in section 8 against a learner within 7 school days. And also, section 28, subsection 2 of the Constitution states that a child's best interests are of paramount importance in every matter concerning the child of justice. If I may proceed.
You may.
Therefore, we humbly submit that the respondent acted unconstitutional and irrational to suspend our clients, as they didn't give them the right to adhere to disciplinary proceedings. For submissions, Justices, Section 39 of the Constitution, subsection 1B, states that when interpreting the Bill of Rights, a court must consider international law. The United Nations Convention on the Child's Rights, Article 15, states that states parties recognize the child's right to freedom of expression in terms of Section 18 of the Constitution, as well as the child's right to peaceful assembly in terms of Section 17 of the Constitution.
If I may just you. Yes, Justice Smith, you can go through.
Counsel, you mentioned the right to peaceful assembly. Can we really say that this protest was peaceful? There were fires that broke out. Students were also prevented from entering the school. So can we really say that this protest was peaceful?
Thank you, Justice, for the question. It is my submission that according to guidelines of freedom of assembly of Africa in paragraph 17, it is stated that the gathering should be deemed peaceful if the organizers are expressing peaceful intentions. And also, Justice, if I may refer you in the matter between Mlungwana versus the state on 2019, case number 32/18. Paragraph 16 states that it is open to a convener to invoke a defense that the gathering took place spontaneously. Justice, also in the matter between.
If I may gauge you there once more, I don't think you have effectively answered my learned colleague's question. Should we consider that the particular gatherings or assemblies in this case were peaceful? But now I will assist you in understanding the question properly. There were 3 gatherings at least in accordance with the hypothetical facts. We have one, the spontaneous one, which was formed, as you are correctly pointing out now. But also 2, we have the other one where they were joined by about 40 students. And then thirdly, we have the other one where they were joined about 100 students. Now, should we consider that all of these gatherings were peaceful, bearing in mind that in one of the gatherings, bins were taken to the gate and set to fire? next or close to the teacher's car park, should we consider that these assemblies were indeed peaceful?
Thank you, Justice. As I earlier submitted that according to guidelines of freedom of assembly in Africa, it is stated that gatherings should be deemed peaceful if the organizers are expressing peaceful intention. And also, Justice, if I may refer you to the matter between South African Transport and Allied Workers Union versus Governors, also known as the Sitau case, on 2013. The Constitutional Court stated that everyone has the right to go out and picket, present petition, and demonstration for any lawful purposes. And also, the Constitutional Court later stated that.
Counsel, I agree with you. In Sitau, we specifically said, yes, everybody has got this right. But at paragraph 53 of that judgment, you would recall that we specifically said, nothing said in our judgment detracts from the requirement that the right in section 17 must be exercised peacefully. It is important to emphasize that when holders of this right exercise this right, they must do so peacefully. Now, with my earlier indication, bins were burned close to the teacher's car park. Is this really peaceful? I don't want to know what is peaceful, that peaceful is if they have the intention. Do you consider the conduct that I have given you to be peaceful, yes or no?
Thank you, Justice, for the question. For the matter of time, Justice, I would like to answer your question and then come to my conclusion. Justice, it is my submission that in the very same case, the Sitau case, in paragraph 62, the Constitutional Court stated that spontaneous and organized protest and demonstration are important way in which people can express themselves. Justice, it is my submission to you. I would like to draw the court's attention in the matter between Antonio versus Governing Body of Settlers High, where the Constitutional Court stated that a question should be asked whether the prohibition is aimed at promoting positive discipline or not, while we know that these 6 learners are minors. Justice, I would like to ask for 30 minutes for the prayer, 30 seconds for the prayer. Counsel for the applicant submits that it has made solid arguments in favor of the 6 learners and prays to this court to dismiss.
You can assume that we know your prayers. Thank you very much. We may now hear from the respondent.
Thank you, Justice.
Respondent.
As it pleases the court, my name is Samkele Mpongisa, together with my co-counsel, Mikaya Chetu. We appear on behalf of the respondent, the SGB of Mjondolo Combined. I will be speaking for 10 minutes and my co-counsel will also be speaking for 10 minutes. I will be addressing the first issue concerning the constitutionality of Section 4 of the School's Code of Conduct, as it does not violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution of the Republic of South Africa, 1996, which I will later be referring to as the Constitution. My co-counsel will be addressing the second issue concerning the constitutionality of the SGB's decision, as it does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the court, I would now love to begin with my submission.
You may proceed, counsel.
I am going to show that a conducive quality teaching and learning environment requires a culture of discipline. Therefore, limiting privacy for this purpose is reasonable and justifiable to the extent that it balances the 5 factors as required in Section 36, subsection 1A to E of the Constitution. Before I analyze Section 36, let me deal with two issues first: consent and context. When one chooses to become a learner of a school, one implicitly agrees to be governed by the code of conduct in question. We say that one also implicitly waives their right to privacy when a school they join has a culture that warrants the restriction of this right.
Apologies, Council. I think the language that you are using is really intriguing me. Are you saying effectively that if you and I enter into an illegal contract because you are in my institution, you sign away your constitutional rights?
Your Justice, thank you for the question, Your Justice. However, in this case, we are not saying that you actually give away your constitutional right. However, we say that when you come to our school, you give your right to be open to limitation as the code of conduct of the school warrants that.
Yes, but a constitutional right cannot be limited by a school's code of conduct.
As it pleases the court, Your Justice, a constitutional right can be limited by a person, Your Justice, of which now we're saying that.
Which provision would allow us to limit a constitutional right?
As it pleases the court, Your Justice, may you repeat?
Which provision which allow us to limit another right?
Section 36 of the Constitution, Your Justice, would allow us to do that.
So then show us how you have limited the right in terms of Section 36, not in terms of the Schools Act or the school's code of conduct.
Yes, Your Justice. As it pleases the court, Your Justice, Section 36 of the Constitution states that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and lastly, less restrictive means to achieve the purpose.
Thank you, Counsel. Just a quick question from me here. Now, I think it's very important that that provision is clear, firstly, on how you ought to limit a right. It's say the limitation must be reasonable and justifiable in an open democratic society and all that, right? I want to know, how is this limitation reasonable and justifiable? How do you say suspension is reasonable and justifiable in an open and democratic society, insofar as the students were not using the cell phones in class? Effectively, they were off, as a matter of fact. So how do you reconcile? There was no disruption that was caused to the learning activities in the school by the learners being in possession of the cell phones. They were merely in possession of them. They were not using them. How is this limitation of this, their right to privacy and even their right to education via suspension reasonable and justified?
As it pleases the court, Your Justice, we say that it is reasonable and justifiable. As Your Justice also stated that the phones were off and the learners weren't using them or they weren't disrupting the class. However, we say that, Your Justice, considering the background of the school, which tells us that it had the ill-disciplined, chaotic, the learners were using cell phones in a disruptive way in a classroom. We cannot trust these learners, Your Justices, that they won't use the cell phones. The fact
but they were not. When the phones were confiscated against them, the learners were actually not using them. So the facts say they were not using them. So why do we have to trust or not trust The facts are clear. They were not using them. They were found in their bags. They were not using them.
As it pleases the court, Your Justice, the fact that they brought the phones to school shows that there were intentions to use the cell phones. Your Justice, for example, when going to school and I bring a pen to school, the intention of me bringing a pen to school is to use it. Your Justice, in this case,
are you saying, so now I'm just going to ask you a hypothetical, kind of a question from what you just gave me now. Are you saying if I'm in possession of the gun or of a gun, I by all means intend to murder a person? Could you not say I'm keeping it in case I'm in a situation where I have to use the gun to defend myself?
as it pleases the court, Your Justice, that is exactly the point, Your Justice. The fact that you have a gun in you, you intend to use it when you are in a situation to defend yourself.
Well, my question basically is like this. If let me clarify it for you. The way I see it is, me being in possession of a gun means I want to defend myself if, for example, somebody tries to rob me or whatever the case may be, which means I'm protecting myself. So I have no ill intention to use the gun and kill somebody, but I will use the gun if I have to protect myself. Can we not say in this case, their learners really had their phones? Yes, that is accepted, but they had no intention to disturb learning activities, as there is no evidence that they actually did use the phones during school time. So can we not say it is reasonable to infer they were going to call their parents to pick them up after school, or they were just going to use it for research during break time, or anything, but something that is not ill-intentioned? Can we not say that?
As it pleases the court, Your Justice, we cannot say that, Your Justice. In the case of they would want to call their parents after school, that is not a reasonable excuse to bring a phone to school, because the parents are the ones also who agreed on the code of conduct. Why would they let a learner bring a cell phone to school, whereas they know very well they agreed on the code of conduct of the school? And secondly,
so just quickly, so suppose there is a case of an emergency, right? And they were going to use their cell phone to call their parents. How then, since they're not allowed to bring their cell phones, how then should the emergency be dealt with?
As it pleases the court, Your Justice, we say that when a learner is brought to school, a learner is not left in an open space, but left in the care of the school, Your Justice. So in this case, the school is the local parentees of the learners. So in this case, they would go to the school or the teachers in the school and tell them the situation, and the situation will be dealt with, Your Justice.
Thank you, counsel. You may proceed.
If it pleases the court, Your Justice, I would now love to quickly touch on the right to education. As it pleases the court, Your Justice, can I request 1 minute of this court's time, Your Justice, just to wrap up on the right to education?
You have 30 seconds, counsel.
As it pleases the court, Your Justice, South African Schools Act number 84 of 1996, as the law of general application in respect of schools, already accepts that the right to education can be limited. The maximum period which it sets already balances the interest of discipline and the right to education. We do not think we need to say much here, except the suspension was a maximum period and the act can catch up 2 weeks later.
Thank
so
you.
I would say that
second counsel for the respondent, you may proceed with the arguments for the respondent.
As it please.
As it pleases the court, as my co-counsel has promised, I'll be addressing the second issue, that the SGP's decision is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. Firstly, I would love to respond on what our learned Fred said. Our learned Fred proved that they said that the strike was spontaneous. But we say that according to Mlungwana and others versus S and others in 2019, in paragraph 16, it states that if a gathering proceeds without a formal notice, then section 12, subsection 1 provides that it is a criminal offense to convene a gathering without giving the requisite notice as prescribed by the Act. And to prove that, Your Justices, it is said again in the facts, that learners went to Precious House.
If I may, I think there's a delay in our devices. However, you would recall that the applicant said that the gathering was spontaneous. In such an instance, are they still required to give notice before the gathering?
As it pleases the court, yes, Your Justices. If it pleases the court, I would now like.
Would you be able to support the argument that there must be a notice that is given even when we are dealing with a spontaneous gathering?
As it pleases the court, it is stated in paragraph 16 of the Mlungwana and others case, Your Justices, that if the gathering proceeds without a formal notice, then the section 12, subsection 1 provides that it is a criminal offense to convene a gathering without giving a requisite notice. As it pleases the court, I would now love to begin with my submission. As it pleases the court, my analysis will show three things. Number one, that the applicants deliberately violated one of the key elements of section 17 of the Constitution. And secondly, that the applicants violated other constitutional protected rights. These include the right to education, free movement, and right associated with free movement, such as free trade, occupation, and profession.
If I may redirect you a little bit, Counsel, perhaps in what we would be more interested to hear is your response to the applicant's submission that you did not comply with the Constitution, firstly, and secondly, with the South African Schools Act, insofar as you suspended the learners without giving them their right to make representation, that opportunity to make representation before suspension in accordance with sections 9 of the South African Schools Act, and therefore your conduct is unlawful. So what is your response to that? They say the South African Schools Act does indeed give you the rights to suspend pupils, but only if you give them the opportunity to represent themselves before you suspend them. You did not give them that opportunity. So what is your response to that argument?
As it pleases the court, may I please repeat the question, Your Justice?
Sections 9 of the South African Schools Act allows you to suspend learners, but only after you give them the opportunity to make representation, to represent themselves. You did not. Why? Isn't that illegal?
As it pleases the court, we believe that as the learners were told that the next day, if they bring their cell phones, then they will be immediately suspended. And in that case, they still bought their cell phones, which means they were trying.
I will thank you a little bit, Counsel, on that. The paragraph, so there's that paragraph that says that if they bring their cell phones tomorrow, they will be confiscated and they will be suspended. But then the preceding paragraph, the subsequent paragraph, the paragraph after that one says, then the principal went on to basically do the search and the seizure. It does not seem to me as if this was today, then tomorrow. It seems as if it all happened in the same day. After she told them that tomorrow, she started the search today, but was just warning those others who would bring their cell phones, the following day. So would we not say that all of these things happen in a space of a single day instead?
As it pleases the court, Well, respectively, Your Justices, the search was not conducted the same day the principal announced that, because the principal even said herself to his statement that if one brings the cell phones the next day, he will be immediately suspended. So we can't.
Counsel, could you read that paragraph for me in your facts? The last bit of that paragraph.
Mrs. Koza warns that as from the next day, cell phones on or off will be confiscated. Let us
paragraph.
That the next day.
Counsel, wait. Read the next paragraph after that one.
The principal orders the search of the bags of all learners.
Thank you very much. Does it seem to you that this is the next day or it's the same day after she makes the announcement?
Well, Your Justice, it is the next day, and we can't prove that it's the same day. As a court, I would now love to continue with my submission. To begin, Your Justices, we say that the applicants deliberately violated the importance element of Section 17 of the Constitution. We accept that the applicants have the right to protest, but they have a constitutional duty to be peaceful in their protest. And if they have no, and the Justices, the key word here is peaceful. Peaceful means that there must be no disturbance and or violence during the protest. Clearly, action that is not peaceful, it is not constitutional protected.
Counsel, if I may engage with you just perhaps for the last time before I stop distracting you. So in our case, we had 3 different marches. In the first one, it was peaceful. And so it complied with the requirements of the Constitution. And we know that the applicants indeed were there. But in the second and the third one, in particular, in the one that leads to the violence, so to say, we are not even certain whether or not the applicants were there because there were no clearly identifiable culprits in those ones. So why should we charge the applicants with, whatever happened there if we don't even know that they were there? Because they were not identified at the scene. Even at the time of the arrest, they were not arrested at the scene itself. So why should we arrest a person who is not placed at the scene of the incident?
The Justices, to answer your question, it is said that it is said in the facts in paragraph 5 that they agreed and started dragging bins to block the school premises, which means their intentions to block the school premises is not peaceful because they are blocking the way of the others. However, Your Justices, that is not our argument. We say that the protest was not peaceful. That's what we're trying to show in this court of law. As it pleases the court, I would now love to continue with my submission. I now turn to the second element of our analysis. In this element, we need to determine whether the applicants infringed the rights of others during the protest. Your Justices, the facts show 3 violations. Firstly, the right of others to get into school and get to the class to study is violated. This amounts to a violation on the right to education. And secondly, Your Justices, we submit that they blocked the SGP from entering the school premises. And finally, they violated free movement for motorists on the day, as it is showed in the facts that they blocked the road. That is an intimidation of confrontation of the motorists, Your Justices. We argue that the right to free movement is an important constitutional right because it is linked to access economic opportunities. For example, Your Justices, one might be going to submit a life-changing CV. They might be going to a once-in-a-lifetime job opportunity, job interview. The self-employed, as it pleases the court, I would love to get a minute to sum my submissions.
Thank you, Counsel. You have 15 seconds.
Your justices, well, let us tell what we submit that what happens if protesters are not peaceful in their protest. Firstly, their issues lose legitimacy. Secondly, they lose sympathy of those who would otherwise pledge solidarity. As it pleases the court, I will just love 30 seconds again to sum up my submissions.
Unfortunately, the court will have to reject that proposition. However, thank you. I think we are quite satisfied with your arguments. We'll now hear rebuttals from the applicant. You may have your leave. Thank you.
Thank you.
As the court pleases, I would like to respond to the submissions made by the counsel for the respondents. The first counsel for the respondents submitted section 36. However, I would like to submit that, in particular, the last factor that is considered, which is the consideration of less restrictive means that are considered while limiting the rights, as in the hypothetical case, it is stated that learners' cell phones were confiscated, and again, they are suspended from school. I humbly submit that double punishment was administered to the learners, and no restrictive means were considered. If I may refer to the section 9, subsection 2 of the South African Schools Act number 84 of 1996, it provides that the sanction imposed on a learner must not be punitive, but must be intended to rehabilitate the learners. My co-counsel had submitted before that in the matter between Antonio versus governing bodies of Settlers High, the case of 2002, at paragraph 17, it is stated that the Constitutional Court stated that the question should be asked whether or not the prohibition is aimed at promoting positive discipline. We, the counsel for the applicants, humbly submit that there must have been other lenient alternative ways that the counsel for the respondents could have considered, such as after the confiscation of the learners could have been taken to counseling and parents' involvement could have been considered. However, the SCP did not indicate as to why these options were not provided. Therefore, I humbly submit that the SGP's decision is not constitutional.
Thank you very, very much, counsel, for your submissions. We will now hear brief comment from our judges. We are already running a little bit late on our next session, so our judges will be very brief and we can proceed. Thank you. I think we will hear first from Justice Smith.
Justice Matthews, you go first, please.
Thank you. From me, quite one comment really. You guys were great, but I think you should all remember that a moot is effectively a conversation between you and your audience. And so do not be intimidated when your bench is engaging with you. You will be, in sessions where some of the judges will be like some of us asking a lot of questions, and in some benches, you will have more calmer judges like Justice Ozar here, who will be a bit more calm. So be prepared for either or. If you receive the far end of, the judges that are persistently asking you questions, and if you receive the far end of judges who want to hear you and will probably only ask you questions at the end of your submissions, just be prepared for either or. Otherwise, I enjoyed it, and I wish you guys all the best moving forward.
Thank you, Justice Matthews. I concur. And then I'd also just like to say, I can definitely see that you guys have done a lot of research. You can quote the laws, you can quote case law, etc. But what I want to say is don't try to quote it too much. Take a step back and think about the facts and the questions you're being asked. Because sometimes it's not that we want the law, it's what we want, how it is applicable to your case and how it assists your case. So that's what I wanted to say. And thank you so much for a really good round. You guys are really good, and all the best with your next rounds.
Justice Ozar.
Thank you so much. Yes, I think from my side, I also agree with my co-judges. Very well prepared. As Justice Smith was saying, I think it's very important when you get questions, also focus on trying to make sure that you're answering the question. That's a very important thing, is that it's an opportunity for you to really engage with applying the law or the case law onto your facts and show the judges that you really understand it. It's not just about knowing the name of the case. How does it fit with your argument that you're trying to make? But you guys are very great. You've done really incredible arguments, better than some of the real counsel we see in real life courts. So all the best for the rest of the rounds. Yeah, thanks.
Thank you very much. The teams, you may be excused. You may go prepare for your next round, or you can go join your next session. Thank you very much. I will just remain with the judges in the meantime. Team supporters, I'm also going to remove you. It needs to be a judges session only. All right, judges, can I kindly request that you DM me your scores for the applicant, the overall score for speaker 1, overall score for speaker 2, overall score for respondent speaker 1, overall score for respondent speaker 2, so that we can have them processed as soon as possible. The score sheets generally take a little bit longer to be finalized. So we will receive the score sheets later, but if I can just have those marks already. I will admit the next teams that are supposed to be coming in, and we will hear from them just now. It's supposed to be 214 as the applicant and 212 as the respondent. Their audios are still connecting, I think. All right, there. Hi teams, I see we have 214. 214 is appearing as the applicant. Team 212, you will be appearing as the respondent. So I will just quickly assist you with your renaming there. 212R. There you go. Team 113, I will remove you out of the session. You are not supposed to be in this session. I see a team supporter, TS. I am not sure for which team you are here to support. So kindly indicate the team number that you are here to support as soon as possible so that we are able to commence with the session. In the meantime, can I kindly request the applicant and the respondents to basically send us the first oralist name, the second oralist name, how long the first oralist will be taking, how long the second oralist will be taking, and if any time is reserved for rebuttal. I will give you about a minute to please quickly finalize that with us as we also wait for the team supporter to finalize the renaming of their names here. Please indicate whether or not the individual is the first oralist, the second oralist, and how long each of them will be taking. All right, I see the applicant is done with that. Respondent, I will give you 1 minute to quickly do that for us.
Sir, I wanted to ask if you can see us both, and if you can see us both in colors.
Yes, we can.
Okay, thank you.
All right, I think we can commence. The respondent, I assume you will each be taking 10 minutes. I have your names now. And I see that it says 10 minutes for the other speaker, so I'm assuming it's both 10 minutes. The applicant, you can basically commence. You can introduce yourself and basically start with your arguments. I will be keeping track of your time. So just look at me once in a while to check how far you are going in your time. Thank you. You can begin.
As it pleases the court, I am Bertha Mutsagani and I'm here with my co-counsel Alu Toluwata, and together we represent the 6 learners of Mjondolo Combined School, the applicants. I will be arguing that Section 4 of the school's code of conduct is unconstitutional as it violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. Whilst my co-counsel will argue that the SGB's decision is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. The counsel for the applicants making use of the Constitution, the South African Schools Act, and articles will prove that Section 4 of the Code of Conduct is, however, unconstitutional. The counsel for the applicants finds Section 4 of the School's Code of Conduct is, however, unconstitutional and irrational. Quoting directly from the School's Code of Conduct, it stated that any learner found in possession of a cell phone will have that cell phone confiscated. Your Justices, that statement is very clear. However, the statement preceding this one stated that, and may be suspended. Now, maybe implies that there's a possibility that a learner who's been found with a cell phone might be exempted from suspension. Paragraph 175 of KwaZulu-Natal versus Pillay of 2008, ordered by the Constitutional Court, stated that the Code of Conduct did not contain any express provision for exemption, either to regulate in what circumstance they would be granted or to establish a procedure whereby exemption could be obtained. Now, this fact is true, as this Code of Conduct lacked clarity as to under what conditions will a learner be exempted from suspension, although found in possession of a cell phone, and as to under what conditions will a learner not be...
May I ask the question? Sorry. Pillay had to do with the right to, obviously the code of conduct, but it had to do with the right to culture and all that, and the fact that there was no accommodation of that. The school conduct was very restrictive and did not have any way of saying, well, yes, under these kind of circumstances, if you say it's my religious belief or my custom that I could wear this, there could be a consideration. Here we're dealing with a code of conduct trying to deal with what would one call a considered misbehavior from the side of the learners, and the code of conduct was adopted because there was a problem. So how do we apply that approach of the court in terms of which right the court was trying to protect versus here where your code of conduct was trying to regulate the particular behavior, one being bringing the cell phone onto school premises and how that was affecting learning? How do you apply Pillay onto these circumstances?
Thank you so much, Your Justice, for that wonderful question. The Pillay case, however, speaks about the exemption that was not provided, that the Code of Conduct did not express any exemption as to like, was there a way out? The same with the Code of Conduct that Mjondolo Combined School had. It stated that maybe, but it did not go as far as to what does maybe imply. That if a learner is found with a cell phone, can they be exempted from suspension as to what is the condition, what is the conditioning for that? I hope that answers your question, Your Justices.
Yeah, that's fine for now. Let's allow you to proceed. Thanks.
The code of conduct is implemented with immediate effect. We allege its irrationality as it did not comply with Section 8, subsection 1 of the Schools Act, stating that a governing body must adopt a code of conduct for the learners after consultation with the learners, parents, and the teachers of the school. Section 5.1b of the Schools Act of 1996 states that learners must be involved in the formulation of school rules. If the learners were involved in the formulation of Section 4 of the Code of Conduct, we would not be here today to contest its constitutionality.
I don't think that is the truth, Council. I mean, we have how many learners at Mjondolo? We have a lot of learners, and only 6 were found to be in possession of their cell phone. Clearly, these are the 6 that do not comply with the rules, because nonetheless, the school's Code of Conduct was in accordance with the facts properly enacted, and that there were, consultations with all the relevant stakeholders. But like in any other institution, there are those that don't follow the rules, and the 6 here happen to be those ones. So why should we feel pity for them if, the rules were properly instituted and everybody else was following them, but for the 6 of them?
Your Justice, it's not an issue of pity, as it's an issue of rights. It is the school's rights to actually allow the learners to be aware of the rules. And if the learners were truly involved, then they would not be here to contest it. If I make reference
why
to...
are the other learners, why are all the other learners not here? I mean, why is it just 6?
Of the learners?
Yes, why is it just 6 learners out of probably, as a public school, average number of learners who would be in a public school would be over 500. So why is it not about 500 learners that are present, in this joint application? Why is it only 6 if it is that they were not aware of the rules? And also, can we claim ignorance to the rules in this case?
No, Your Justice. No, Your Justices, as the applicant was not granted a chance to go under a disciplinary hearing. The resistance should, however, be evident that there's a reasoning behind carrying a cell phone, to which the school did not necessarily give allegement to that. Your Justices, may I say?
If I understand you correctly, you are saying that the learners broke the rules because they had a reason which they didn't make the school aware of beforehand, and now we are supposed to find in favor of the learners while they failed to notify the school why they would be bringing cell phones. I'm sure the school would have allowed them to bring cell phones had they had valid reasons that they expressed with the school beforehand, don't you think?
We do allege that your Justices. However, we cannot ignore the fact that the school later on, after having found the cell phones of the learners, did not grant them a disciplinary hearing, to which the learners have a right to. We allege that if the learners were granted a disciplinary hearing, then they could have petitioned their grievances as to why they brought the cell phones in the first place.
Would you say it is still necessary for the school to allow them the opportunity to make representation, which is basically what you are talking about, disciplinary? Would you say that is still a requirement in instances where the rules are clear on what should follow when there has been a violation? In our case, the rules are very clear that in instances where there has been a violation, the individual who is in breach of such a rule must, be suspended. So why should they be given an opportunity to make representation where the rule is clear as to what the consequence of the violation is?
Your Justice, the rules were not exact. As I quoted before, that there was a maybe in the Code of Conduct, which means there was that states that there's an exemption, but it did not go further to clarify as to under what conditions would that exemption apply. If that answers your question, Your Justices.
You may proceed.
Thank you. Umjondolo Combined School lacked discipline, hence the Code of Conduct. With reference to the consideration of adopting a Code of Conduct, which was recognized by the South African Schools Act of 1996, it states that a Code of Conduct must not be punitive or punishment orientated. We submit that Mjondolo Combined School was very focused on punishment, as teachers were now making use of corporal punishment to which the respondent did not reprimand, and that all 6 of the learners were suspended, and that learners were not being punished for the smallest of transgressions. Paragraph 17 of Attorney versus the governing body of 2002 states that the question should be asked in this regard, whether or not the prohibition is aimed at promoting positive discipline, and whether or not non-compliance therewith justifies punishment or some other form of sanction. Now, your justices, we allege that we submit that cell phone carriage does not, however, justify suspension for the rest of the year. The respondent dismisses the learners during school hours. Your justices, this is absolutely humiliating, and we have reasons to believe that the respondent could have and must have dismissed the learners after school and allowed them to progress with the day's lessons. The mere fact that the respondent was quick to dismiss the learners during school hours shows that this code of conduct has no regard at all for the learners' rights to basic education and human dignity in terms of Section 10 of the Constitution. Section 8 of Section 2 of the Schools Act states that a principal and his or her delegates may conduct a search to a group of learners for dangerous objects and illegal drugs. Ms. Khoza orders a bag search and 6 cell phones are found. Your justices, a cell phone is nowhere dangerous or illegal, and nowhere in the Code of Conduct or the Schools Act does it warrant a cell phone search. Therefore, to that reasoning, the respondent has violated the learner's rights to privacy in terms of Section 14 of the Constitution. Your justices, I have come to the end of the argument.
A little bit. I mean, when we are dealing with the right to privacy in public spaces, clearly that right isn't as, attenuated, is not as protected in public institutions, etc., because of the nature of the environment itself. So would you not say to us that perhaps the school limited that right correctly, because obviously in public spaces, the right to privacy isn't as strong, or its protection isn't as strong?
Your justice is making reference to Section 14 of the Constitution. It states that everyone has the right to not have their property searched. And in making reference to Section 8 of Section 2 of the Schools Act, it states that the principal may only conduct a search after suspicion of dangerous and illegal drugs, to which cell phones are not illegal. And the Code of Conduct and the Schools Act does not support searching the learners for cell phones itself. Therefore, the cell
phones would not be illegal under general circumstances, but they would be illegal in this instance because the school's Code of Conduct regulates their illegality, which means it is illegal in that instance, on the first leg. On the second leg, however, this very court, the court that you are appearing before, and you have about 30 seconds remaining, has previously indicated in the Ministry versus Interim Medical Council of South Africa that when we are dealing with the right to privacy in public spaces or institutions, the protection of this right is not absolute at all. And so that's what I want to gauge from you. What is your perspective of that? How do you then say we should still protect the right to privacy in public spaces, even though this court has previously said when we are dealing with the right in public institutions, it's not as strong and can be limited quite easily or flexibly? I'll give you about 20 seconds to answer my question and just wrap up.
Thank you so much, your justices. Your justices, we submit that if truly the respondent was not trying to violate the learner's rights to privacy, then they should have asked for permission to begin with. However, it was more of it was more imposed than it was of the consultation if the learners did want to be searched. And I hope that answers your question, your justices.
Well, thank you very much. We may now proceed to...
Counsel, before you proceed, I have one question for the first counsel for the applicant. Rules are meant to instill discipline in learners. It's meant to teach them from a young age to abide to rules. And so you're saying because these learners were not consulted in enforcing this code of conduct, they can merely just disregard it and do as they please. What is your submission in respect of that, given that we are preparing these learners for society at large, and there are various rules that they will have to follow?
Thank you so much, Justice, for that wonderful question. Your Justice, I have to submit that I have to deny the fact that the respondent was trying to instill any rules for the future. As if truly that was a fact, then they would have granted the learners a disciplinary hearing, to which they denied them of that. They did not practice Section 9 of the Constitution, which is equality, as they only granted a hearing and not the 6 learners. So then how are they then training the learners for the future and instilling rules in them? Therefore, with that reasoning, the justices, the learners were not incorrect after all.
Thank you, counsel. The second counsel for the applicant, you may proceed.
As it pleases the court, I am Aluto Luata, and I will be appearing on behalf of the applicant. Your Justices, with 9 minutes of analyzing issue 2 being the submission that the SGB's decision is indeed unconstitutional, as it does violate the applicant's rights to privacy in terms of Section 17 of the Constitution. We submit that in accordance to Section 39, subsection 1 of the South African Constitution, it states that when interpreting the Bill of Rights, a court, tribunal, or forum must consider international law. Reason being that South Africa ratified the treaty and has agreed to be bound by its provisions. In Article 21 of the United Nations International Covenant on Civil and Political Rights, the right to assemble shall be recognized, and that no restrictions may be placed on the exercise of this right. We also state that this right may be exercised.
If I may, all of these instruments, international, domestic, continental instruments that South Africa has ratified, all indicate that the requirement, the qualifier for the exercise of this right to assembly, this right to petition, this right to demonstrate, to gather, is peaceful. In this instance, you have learners who burned dustbin, that is property, outside the school gate near the teacher's car park. Would we consider this action, these conducts, to be peaceful in accordance with all these instruments that you are naming to us?
Your Justices, regardless of how the protest had ended, we submit that the police did inspect the scene and no culprits were identified. Second, we submit that according to Section 11, subsection 2A of the Gatherings Act number 205 of 1993, it shall be a defense to a claim against a person or organization contemplated if such a person or organization proves that he or it did not permit or connive of the act or omission which caused the damage in question, and that this act did not fall within the scope of the objectives of the gathering and was not necessarily foreseeable. We submit, Your Justices, that the intentions of this protest was rather to just discuss the unfairness of the situation, and it was never the intention of the applicants for the damages that was caused.
That's a great response you have given me there, which now makes me want to assess, and if you may indulge me on this one, were the students suspended before or after the protest?
Your Justices, the students were first suspended before the protest and also after the protest.
So which suspension is effective?
The second suspension.
How are they suspended 2 times?
They were first suspended for the cell phones, and then secondly, after the meeting had taken place, they were suspended for the maximum period, which is for the protest as well as the cell phones.
Is it not that the students were suspended for the cell phones, and then it was confirmed that they were suspended for the maximum period later, not that there were 2 suspensions? How do you suspend a person who is already suspended?
Oh, Your Justices, but they did not allow the learners to protest. They tried to stop the protest, yes.
Yes. So which means when we are dealing with the protest, we are not necessarily dealing with the suspension of the students, but we are dealing with the nature of the protest itself, right?
Yes, Your Justice.
And the consequences which should follow where the nature of the protest is not peaceful, right?
Yes, Your Justice.
So perhaps address us on that. Let's leave suspension out. They are already suspended. Let's address how their right to petition, to gather, to demonstrate has been unlawfully, so to say, cut off.
Yes, Your Justice. We'd like to first refer to the Gatherings Act number 205 that states that this was rather a demonstration, as it was just the 6 of the learners, and the rest of the learners started joining this protest only after, Your Justice. This proves that the applicants can never restrain the rest of the learners of Mjondolo that also found that Section 4 of the Schools Code of Conduct was unconstitutional. Therefore, we submit that, Your Justices, the courts are to rule that the rest of the learners were merely just witnesses to the unfairness of the situation. We also state, Your Justices, that paragraph 16 of the Mlungwane and others versus S and another that was ordered by the Constitutional Court in the year 2019, that it is open for this convener to invoke a defense that the gathering that took place spontaneously. So, Your Justices, we do submit that this protest was rather one that took place spontaneously. That answers the question.
But we are not dealing with one incident of a protest. We are dealing with 3 incidences of a protest. We have the first one where they are told by the police, please disperse, and then they go back to Precious's house. We have the second one there where there's about 40 students joining in. And then we have the third one where we have about 100 students now joining in. Now, the first one, I will concede, I think it was really peaceful. It was without notice. It was spontaneous. But the other ones, there was no notice given for them, which means that they were effectively illegal, and 2, there was violence that erupted. So how do we then, address, how do we cure these issues there?
Your Justices, the violence that was addressed, the police did inspect the scene and no culprits were found. So therefore, Your Justices, we cannot state that it was the applicants that caused the fire in the school or so and so. And Your Justice, as I stated,
reasonable inferences that the applicants, as the people who convened the first and the second, and with the WhatsApp chats that we found, that it is reasonable to believe that they were the people that actually convened the ones that erupted the violence. I mean, they were the only ones that were suspended. Nobody else had, an interest, so to say, in challenging the school because no one else was suspended.
Yes, Your Justices. However, it still doesn't derive from the fact that no culprits were identified, and the fact that, Your Justices, the applicant was merely just trying to. They were just practicing their rights to a protest, and therefore they can never
understand that. But my question effectively is: can we not make the assumption? Can we not infer? Is it not reasonable for us to infer that because they were responsible for the other, they were responsible for the one that caused the violence as well, given the facts surrounding everything? Is it not reasonable for us to believe it was them who was responsible for it, even though they were not identified at the scene?
It is not reasonable for us to do so, Your Justices, because they were only recognized to leading the protest, Your Justices. So there was no proof to the fact that it was indeed, if I'm answering your question, Your Justices, they were merely identified and they were recognized. Your Justices, as my time is running out, I would like to conclude that, Your Justices, we refer to in conclusion, we respectfully request that this Honorable Constitutional Court orders that indeed Section 4 of the Schools Code of Conduct is unconstitutional, violating the rights to privacy and a basic education in terms of Section 14 and 29 of the Constitution. We also plead that the court orders that the SGP's decision is also unconstitutional, violating the applicant's right to freedom of peaceful assembly in terms of Section 17 of the Constitution. And lastly, Your Justices, if the court does rule in favor of the applicants, that it releases all the 6 learners of their suspension so that effective education can proceed. If it pleases the court, I will take permission to take leave.
Thank you very much, Counsel. You were right on time. We will now hear arguments from the respondent. Respondent, first oralist, you may proceed. Thank you.
May it please the court. My name is Sam Stanop and I'm with my co-counsel Vitabile Mula, and we appear on behalf of the respondent. The question before the court is whether the applicant's right to privacy and basic education has been violated by the implementation of Section 4 of the School's Code of Conduct or not, and whether the SGP's decision has violated the applicant's right to peaceful assembly or not. We submit that the applicant's rights stated in Section 14, 17, and 29 of the South African Constitution were not violated, and that Section 4 of the School's Code of Conduct is not unconstitutional. Counsel for the respondent therefore argues in line with Section 24 of 2005, South African Schools Act number 84 of 1996, and the case between the head of Department of Education, Free State Province against Welcome High School. We strongly believe that the respondent acted legally. Section 4 of the Schools Code of Conduct is not unconstitutional. South African Schools Act number 84, Section A, subsection 1, explicitly states that the SGP of a public school may, after a fair hearing, must adopt a school code of conduct after consulting with learners, parents, and educators of the school. We submit that the respondent did go through a consultative process, and by the majority's will, the code of conduct was implemented. In South African Schools Act number 84, Section 8, subsection 2, and the judgment that was given in the case of the head of Department of Education, Free State Province against Welcome High School, it was stated that a code of conduct must be aimed at establishing a disciplined and a purposeful school environment dedicated to improving and maintaining the quality of the learning process. In this case, the SGP implemented the school code of conduct.
Counsel, if I may quickly just interject you a bit there. In Welcome, I think what the court specifically was looking into was the issue of positive discipline, just as the court was doing in Antwani. And what that is basically discipline that is aimed at promoting educational means. In effect, we are looking into disciplining but not punishing the students. Would you not say in this case, the students have effectively been punished but not disciplined?
No, you're not. The applicants were not punished, but the code of conduct was aimed at maintaining the quality of the learning process. Hence, it was poor at that time, and the discipline too.
Yes, but I mean, the code of conduct aims to achieve the goal of the aim of the code of conduct is basically to ensure that the learners are not effectively using their mobile cell phones during the learning and teaching process, as that used to be the problem. The learners in this case, the applicants, were not using their mobile cell phones when they were confiscated, were they? So it seems to me that the aim of the enactment of the provision has been fulfilled. So why are you punishing the students? Discipline would be giving the students detention, extra work, etc., because you would not be depriving them of their right to education. But in this instance, you are depriving them their right to education for the maximum period of time. And that doesn't seem to me like positive discipline at all.
May I just, sorry, Mr. Stanop, while you're preparing that response, actually, I want to add to what my Chief Justice just asked you, because that's precisely the thing that also even in Welcome, in the Constitutional Court asked the school to revise the specific policies because that they did amount to a punishment rather than, disciplining the pregnant learners. And that is a very crucial question that my learner colleague is asking you. What is the purpose, and also then how the enforcement of that in a way that actually helps to maintain discipline versus one where your response is purely punitive, which is what the applicants in this case are complaining about.
The punishment of the applicants was based on that the applicants were standing in a way of maintaining discipline and improving quality education for the school that was struggling for a longest period. Therefore, there were difficulties of teaching in the school and learning. So with people opposing and violating the code of conduct, then that meant that the school was going to be in the same state as before. The SGP
Sorry, Mr. Stanop, can you apply that to the facts, which is that the phones were found in their bags. They were not busy with the phones physically in the class. The phones were found in their bags. So if you're saying, sure, the code of conduct said do not bring, but if I brought it, it's in my bag, I'm not even using it, I'm just sitting in class, and then there's this session Caesar. How did that actually affect when the phones were just sitting in the bags? How did they, nobody knew that they were there until there was the session Caesars. The students were not parading them, they were not using them. So to my mind, they were not in any way affecting the teaching and learning practically. It was just when the session Caesar happened and they were found, and then this response of now we have to be hardline and apply the code of conduct as hardline as it stands. We apply that approach to the facts, because the facts are that the phones were found in their bags and most of them were even off. How were they affecting the learning, which is what was the reason why there was an issue with in relation to having phones at school?
Learners, especially those who are addicted to using their cell phones, will be tempted to turn on their cell phones and use them. So that will make the student not to focus on the lesson, rather to focus on how to turn on their cell phones without being seen. So it was best to completely ban cell phones from school.
Council, if I may just add on to the questions that were asked. One of my justices asked earlier on, why is it necessary to suspend the learners? Why couldn't the school take an alternative approach? Why was it very important for them to suspend the learners as opposed to, offering them detention, etc.?
The applicants, as I said, the applicants are standing in the way of maintaining discipline in the school and maintaining quality level of the learning process. So as there were difficulties in the school in teaching and learning processes, the school saw it necessary to remove people who are influencing the quality, in a big way, the quality of the learning process and discipline. And the SGP decided to be harsh on the learners or applicants, and after a while, they noticed that maybe they are being too harsh on the learners, and they called parents meeting in intention of rectifying their mistakes. However, the applicants blocked them from doing so.
You may proceed, Council.
Thank you. In this case, the SGP implemented the school code of conduct after analyzing what is best for the school and learners and how the code of conduct can assist in improving the academic performance of learners. All in all, we can proudly say that the code of conduct was aimed at improving and maintaining the quality of the learning process.
Mr. Stanop, the learners are saying you violated the right to privacy. I haven't heard your clear argument about the limitations of rights. So they say that you violated Section 14, which is their constitutional right to privacy. When you, well, firstly, Section 4, Part 4 of the Code of Conduct does that, and then also then the session Caesar that violates their rights to privacy. What is your response to that? Well, because this is a very important constitutional right. So how does that right effectively function in a school environment? What would be your response to the fact that your actions violated their rights to education? To privacy.
Justice, I will address that later in my presentation. Thank you. The use of cell phones in the case of the applicant was clearly inconsistent with maintaining the quality of the learning process. Hence, they were improperly used. If the applicants are valuing the use of cell phones more than education, then that precisely explains that they are the ones who are limiting their rights to basic education and quality education. The SGP fulfilled their duties stated in Section 20, subsection 1H of the South African Schools Act by promoting the best interest of the school and learners, and also ensured development in provision of quality education.
Council, given that you have 1 minute remaining, may you please address us on the right to privacy?
The right was limited as stated that all rights listed in Chapter 2 of the Constitution are not absolute, but may be limited in some instances. So the reason of limiting these rights was that in this case, the search and seizure was done with intentions of maintaining a proper order and discipline, and also to promote a proper learning quality. We also submit that the search and seizure in this case was reasonable, hence the school believed that the learners might be having their cell phones with them after the incident of Mr. Kwele, where Mr. Kwele's cell phone fell out of his pocket and was seen and confiscated by Mr. Nsmcc. Throughout the search, the evidence, Justices, can I please be given 30 seconds to conclude?
You can conclude.
Thank you. Throughout the search, the evidence that supports the suspension of the school was obtained. By bringing cell phones while knowing that they might be confiscated, that meant that the applicants were willing and risking for their cell phones to be confiscated. With those words said, my justices, I believe that I have to descend and let my co-counsel to proceed from where I left, if it pleases the court.
Thank you very much. We will now hear from the second counsel for the respondent.
May it please the court. My name is Ritabile Molawa, as introduced by my co-counsel. I'll be arguing that section 29 and 17 were not violated by the school by the learners. Section 17 of the South African Constitution states that everyone has the right to assemble, to picket, to demonstrate, and to present petitions. In this case, counsel for the respondent does not deny that the applicants were unarmed when protesting. However, not only did they not practice their right to peaceful assembly, they also vandalized the school's property by setting the administration block on fire and attacking the school's property. Attacking the school's property violates the right.
Did they set the administration block on fire? Now that's arson. Did they set the administration block on fire, or did they set the dustbins on fire?
They set the administration block on fire and the church being next to the teachers' car park on fire.
So where on the facts do we see that? If you could just perhaps read it out from the facts. Look on page 3, if I may guide you.
It says that evening, the evening before the second protest, that evening, there is a fire in the administration block on the school. In the second protest, it is stated that
Counsel, in that very same paragraph, it also says no culprits are identified. So how can we infer that it was these learners?
Or even learners at all?
We can say that it is the learners because they are the ones that have been complaining from the beginning that the school is unconstitutional. So we might assume that it was the learners that started the protest and set the administration block on fire.
But why would we assume that it is the learners when the facts don't tell us that it's the learners? And so far as we know, the learners were at Precious's house, maybe when the fire commenced. So why should we assume that it is the learners who actually were responsible for the fire? For the dustbins, yes, it was the learners, but for the admin...
We might assume that it was the learners that started the protest because there was a protest before the second protest and it was held by the learners. So the second protest, we might assume that it was the same learners who protested the day before the second protest.
Why can we not assume that the parents of the learners were unhappy and perhaps it was the parents and not the learners themselves?
We might assume that it is the learners because the learners are the ones that are particularly having a problem with the conduct of the school and the suspension.
You may proceed.
Attacking the school's property violates the right stated in Section 29 of the South African Constitution, which states that everyone has the right to education, including adult and further education, which the state, through reasonable measures, must make progressively available and accessible. The applicants infringed the right of the other learners by making it impossible to access the school. We submit that any student who vandalizes the school's property must be held accountable for the action and must be subjected to disciplinary hearing, including the possibility of suspension and expulsion from the school's activities. Counsel for respondent is arguing in accordance to Section 9 of the South African Schools Act of 1996, which states that the SGB has every right to suspend a learner from school after following the correct procedures. In this case,
and the proper procedures would be the opportunity to make a representation, which the applicant has correctly pointed out has not been given to the applicants in this case. Nowhere in the facts do we see that the applicants were given the opportunity to make representations before they were suspended. Isn't that a violation of the Constitution in Sections 9 of the South African Schools Act?
Justice, please give me a moment to find the answer to your question. Justice, can you please repeat your question?
The question was, the applicants said that you failed to give them the right to make representations before you suspended them. The law requires that before you suspend a learner, you give them the opportunity to make representation. Since you did not give them that opportunity, isn't that a violation of their rights? And therefore the suspension is materially irregular and we should probably set it aside and they should go back to school.
We submit that the applicants are also not certain that they were not given the opportunity to make representations in the disciplinary hearing. Hence, it was not stated in the facts.
No, but they were not given. They were suspended immediately. The facts indicate that they were suspended immediately. They were not given the opportunity to make representation.
So what is the exact question, Justice?
My question is still the same. I was just answering you on the fact that we are sure that they were suspended without being given the opportunity to make representation. So doesn't that mean that you suspended them illegally?
Well, it does not mean that they were suspended illegally, Justice.
What does it mean? If you don't give them the rights that they deserve in accordance with the law before you suspend them, what does that mean then?
Well, in this case, we will assume that the suspension was
Counsel, you know when Mr. Stanhope started and he was explaining the process for adopting the code of conduct, he kind of caught him out actually trying to talk about the procedure. He actually made argument that there was something about there's a right to a process before a suspension. And that's what the Chief Justice is asking you. Can you suspend a learner without having had a hearing? It's as simple as that, because that's one of the biggest issue that the applicants have with how they were treated. They say that even the Section 4 of the Code of Conduct says that you may be suspended, but when you read that with the overall right to a hearing, could you have suspended them without having heard from them why they acted the way they did, whether they had good reasons, before you come to your decision to suspend them. Does that help?
It does.
Okay.
Can I have a few minutes to deliberate with my co-counsel?
Unfortunately, counsel, not. But you may proceed with your arguments.
It should be expressed that suspending the applicants was not in intentions of violating the right to basic education. However, it was in intentions of instilling discipline within them, and that was done legally. In conclusion, counsel for the respondent argued in line with Section 9 of the South African Schools Act of 1996, South African Schools Act number 84 of 1996, and the case between Head of Department of Education, Free State Province against Welcome High School. We also argued that Section 4 of the Schools Code of Conduct is not unconstitutional, and Section 14, 17, and 29 were not violated. Furthermore, we stated that Section 4 of the Schools Code of Conduct was designed according to South African Schools Act number 84 of 1996. The respondent acted in consideration of what is best for the school and learners legally. Counsel for the respondent.
Sorry, Ms. Mulawa, just a quick question. So you said you acted in the best interest of the other learners and the teachers. What about the best interest of these learners to access education? You know, are your actions in line with that? Because they also have to be considered. Yes, they did something wrong, but when you're considering your way, your sanction or your way of dealing with the issue, it's not just the school and the other learners, it's these particular applicants before this court today. Did you consider their right to education and their own interests?
If I may just add, you have about 30 seconds remaining. Your time is up, so you can just wrap up and conclude.
While the applicants were put under a diversion program that ensured that they still received education even during the suspension. I hope that answers your question.
Right, thank you. We will now hear from the applicants to give their rebuttal.
Your Justices, if it pleases the court, the first counsel spoke about the fact that the school was merely just trying to promote discipline. However, your Justices, if you refer the court to paragraph 98 of the Nsmcc for Education, KwaZulu-Natal and others versus Pillay, that was ordered by the Constitutional Court in 2008, it states, your Justices, that both discipline and education are legitimate goals. However, the care must be taken not to state the school's interest too broadly. Your Justices, the council stated that the school did try to make amendments to rectify their mistakes. However, regarding this meeting that took place, we submit that there was an intervening event that didn't allow the students to join at that meeting. We submit, your Justices, that if truly the respondent was trying to fix any errors, she should have went outside the school gate and paid attention to their grievance. If that pleases the court, I will take my leave.
Thank you, counsel. It appears that Justice Matthews might be frozen. Justice Matthews, are you with us?
I am here. I had a glitch for a few seconds there. Okay. Are we done, everyone? Justice Smith, did you receive my inbox? I'm not sure if it went through.
Yes, I did. Thank you.
Right. Okay, I will allow the judges to basically give brief feedback to the participants. I will go first, followed by Justice Smith, and then Justice Ozab will conclude the session for us. Well done to both teams. I think you guys spoke very well. We are really impressed with your arguments. Moving forward, I think you should remember that a moot is a conversation between you and your judges, so don't get fluxed when you receive questions. A better way of dealing with questions is smiling when you receive them so that your nerves don't kick up in the other opposite direction. So when I get questions in an interview, in a moot, anywhere else that might be intimidating, I smile and I channel the energy of the nerves positively. So smile when you receive a question, and that will allow you to be able to calm yourself from the nerves that are skyrocketing in your system. Otherwise, we really enjoyed it. Over to you, Justice Smith.
Thank you for a really good round. Thank you to both teams. I can see that you guys have done your research and you're well acquainted with the facts. Just a few pointers going forward. In terms of the facts, make sure that it's clear. If it doesn't say something, don't say that it says something, because we won't catch you out. And then also just in terms of answering questions, we can see that you've read the law, case law, etc., but we want to see how you apply it to the set of facts that has been presented to you. So instead of focusing on reading, the legislation or case law, etc., try and relate it to the facts before this case. Thank you so much, and all the best with your rounds going forward.
Thank you. I also agree with the bench, members of the bench, with their comments. My comment will also, be in relation to answering questions. In as much as you have prepared and you have a script or a chronology of argument, sometimes when a judge asks your question, rather answer it then, because you may run out of time without having answered that. And I do understand that sometimes you get a bit nervous. But if the question comes, and because here time is of the essence, please try and answer it so that the judges know that you know what you're talking about and you've spoken about. I think I asked the question and the person I asked ran out of time, which is a shame actually. So try and do that. Don't assume that you will have time later to respond to the judges' questions. But yes, well done and all the best for the rest of the day. Thanks.
Thank you very much. All right, participants, best of luck. You may excuse us now. Thank you. Best of luck. Bye-bye. Okay. Participants are all out. I see Philip is here. Chandra, can you please just send me your scores once more?
Simon, I've emailed. Must I send it to your phone as well? Or are you getting my emails?
No,
I'm going to email now as well. I'm sending this one now as well now.
Okay, I got your first email. So yeah, that's fine. I think the next session is supposed to be at 10:30. Let me just quickly check the schedule. Oh, no, we have a session. Session 3. We are even running late.
Justice Matthews, I won't be sitting in the next 2 sessions. You do have sufficient justices, right?
I think so. Let me just check the judges' schedule quickly to see what judge is supposed to be here. Quarterfinals, 1, 2. Why are these things not? Oh yes, Lindy Sanderson is supposed to be joining us. Because Joyce didn't. Thank you, Chandra. Let me just quickly call Joyce. Wait, is Philip still here? No, he is gone. Let me just quickly call Joyce. The judge's schedule and the team schedule are not matching. Because I think according to the judges session, the next round is we are supposed to have a break now. Let me see what the program says. And I think Joyce just made all of them at the same time without. Let me admit these ones on the side, and meanwhile, while I'm looking for the program. Today is quarterfinals. Oh, we are running late, so we are in the third session. Okay. Thank you for the scores, Chandra. Let me just quickly forward them to Joyce. Hi, teams. Apologies.
Simon, in terms of the schedule, session 3 is supposed to start at 10:30.
Yeah, I think Joyce didn't. Oscar, I also got your scores. Thank you. Joyce didn't amend some of the things. So, yeah, the team schedule and the judges schedule are no longer the same. It's working under pressure, I guess. Shame.
Will Justice Mayor be joining you?
I don't think so. She's got the judges schedule, which makes it problematic. Are you available to join in?
Only in the event that the other judge isn't able to join at all.
Okay, let me just quickly see if I can get hold of somebody. In the meanwhile, can I please kindly request the teams to basically write out in the chat box the name of the first oralist, the name of the second oralist, the amount of time the first and the second oralist will be taking, and if any minutes are reserved for rebuttals. Obviously indicating which team you are appearing for as well. I see Lindy is here. Hi, Lindy.
Hi, Simon. Good morning, everyone.
All right, Chandra, I think we will be sorted.
Thanks, Simon. See you guys later. All the best.
Later. Bye-bye.
Simon, I'm on for 10:30, right?
Yes, this will be the session, I think, already.
Okay.
If I may repeat that for you participants, please kindly indicate who the first oralist is, who the second oralist is, and what amount of time each of you will be taking for both the applicant and the respondent. And put them for us in the chat for everyone to see. I'll give you about 2 minutes to basically finalize that. Thank you very much, teams. I see the respondent, the applicant. Yes, all here, the judges. You can access the names of the participants on the chat. I see the applicant is 212 Ritabile Molawa, speaking for 8 minutes as first agent, and then Tando Stanop is second agent, speaking for 10 minutes, and 2 minutes is reserved for rebuttal. The respondent, team 117. First speaker is Tsipogazim Charlie for 10 minutes, and the second speaker is Nonduduzo Dangazela for another 10 minutes. All right, I will be keeping track of your times, so be on the lookout as to how far you are with respect to your times. And with that being said, we can hear arguments from the first speaker of the applicants. We will interject as the bench as you make your arguments in between, but remember, we are having a conversation with you, and that's all it is. Best of luck.
May it please the court. I am Retavile Molawa, and my co-counsel is Stanop. In this case, we'll be arguing that Section 4 of the Schools Code of Conduct is unconstitutional and violates the applicant's right to privacy, and that the SGP's decision is unconstitutional as it violates the applicant's right stated in Section 29 of the South African Constitution. We also argue that Section 17 was violated by the school by means of restriction. I'll be dealing with Section 17 of the South African Constitution, and my co-counsel will do Section 17 and 29. Section 14 of the South African Constitution states that everyone has the right to privacy, including their right not to be searched or to have their possessions seized and the privacy of their communications infringed. We argue that Section 4 of the Schools Code of Conduct is unconstitutional as it violates the applicant's right to privacy. The principal further violated the learner's right to privacy when she ordered that all the bags of the learners are searched. Honorable Justices, as indicated earlier, the applicants have the right not to be searched. Counsel for the applicant is aware of the authority given to the SGP to adopt a school code of conduct. However, the contents of the code of conduct must be consistent with the Constitution of South Africa, which is the supreme law of the Republic. In this case, we submit that the contents of the code of conduct are inconsistent with the Constitution of South Africa as per Section 2 of the Constitution of South Africa and should be declared invalid. Counsel for the applicant also notes that the Constitution of South Africa provides a general limitation clause at Section 36 of the Constitution. However, the rights might be limited in means of law of general application, and that the limitation must be reasonable and justifiable in an open and democratic society, looking into account human dignity, equality, and freedom, taking into account all relevant factors. We therefore submit that the applicant's right to privacy should not be subjected to this clause. We also submit that, according to Section 2 of the South African Constitution, the obligations imposed by the Constitution should be fulfilled. Therefore, the obligations imposed at Section 14 of the South African Constitution should be fulfilled. The school should not have banned the possession of cell phones altogether. However, they should have examined.
Let me just interject you a bit there. Apologies. I think you are really making a good argument insofar as you are indicating the importance of the right to privacy. However, isn't the right to privacy a little bit easier and flexibly limited when we are dealing with that particular right in public spaces, public institutions, public activity? For example, this court has previously, I think in Mystery versus Interim Medical Council of South Africa, said that that right or the protection to that right isn't as strong when we are outside the realm of a person's personal, private, space. Once we are in public spaces, the right is not as strong, or the protection to that right is not as strong anymore. What do you then make of that? What is your response to that, counsel?
Our response to your question, Justice, is that the right to privacy may be limited only if the limitation is reasonable and justifiable, taking into account less restrictive measures to achieve the purpose of the limitation.
So how is it not reasonable in this case?
We believe that it is not reasonable because the school did not have reasonable suspicions to invade the learner's privacy.
The school did when they caught Sviso with the phone in violation of the school code of conduct. They had reasonable suspicion that other learners were similarly in violation of the school code of conduct. And that is why they then searched the search and the seizure after giving the students a warning that the following day, the search and the seizure would okay and suspension, obviously. So the suspicion was there, it was reasonable. So what is then your argument in respect of that?
Well, our argument will have to be that we submit that the applicant's right to privacy should not be subjected to this clause because it is stated that the right to privacy the right to privacy states that everyone has the right not to be searched or to have their possession seized. Therefore, what entails should be fulfilled. And we submit that the Constitution of South Africa is the supreme law of the Republic, meaning what the Constitution says goes. So the school did not have the right to limit the right. The school should not have banned the possession of cell phones altogether. However, it should have examined all the relevant factors, including the fact that cell phones may have a positive impact on the learning process, including improved learning outcomes, increased engagement among students, and an easier ability to keep students up to date about the necessary schoolwork. Possession of cell phones can also help in a state of emergency, where, for instance, a learner is put in detention and will be dismissed a bit later than usual. The learner will need the cell phone to keep in contact with the parent or guardian in case the learner needs transport. We also argue that the SGB should amend Section 4 of the School's Code of Conduct in a way that less restrictive measures are considered. The school should allow learners to bring their cell phones with them to school, but will only be permitted to use their cell phones in the morning prior to the school bell ringing, during recess, and after school. It will therefore be the responsibility of the learner to ensure that the cell phone is off during lessons. Failure to do so, then confiscation will be necessary. I've stated my case. I'd like to hand over to my co-counsel to deliberate further, if it pleases the court.
Counsel, you have about 2 minutes of your time remaining, so I think this would be a good time for the judges to, engage with you a little bit. I will go first. You have made very good arguments, but I want us to consider that the respondent at face value might concede that at face value the search and the seizure exercise would be unconstitutional, but Section 7.3 of the Constitution reminds us that the right is subject to limitations in accordance with Sections 36, as you have correctly pointed out, which stipulates that all these rights are not absolute. Now, can we not say that this limitation was indeed appropriate in the grounds listed in Sections 36, especially noting what the court held in Ntoyake, that you can't just use the word search and seizure, the word search and seizure, just in J. When you use the words search, it means there must be a consequence that follows, which means when you search, you must also have the authority to seize something. Because if you only search, you find evidence of, the commission of a crime, say in another instance, it would have been a gun, and you don't seize it, then, you don't have evidence that there was a rule that was broken. So in this instance, don't you think that the seizure of the mobile cell phones was in fact an appropriate measure taken by the school?
No, Justice. Ever has stated earlier that due to the Constitution of South Africa, it is stated that the right to privacy clearly states that everyone has the right not to be searched or to have their possessions seized. The law is above the school and the code of conduct. Therefore, what it entails should be fulfilled. If the school wishes to limit the right, then the limitation must be reasonable, taking into account less restrictive measures.
But wouldn't you say that the search and the seizure is less restrictive?
No,
What else
Justice.
would they have done except for taking the cell phones?
The school should have taken into account less restrictive measures by allowing the learners to bring their cell phones with them to school, but will only be permitted to use the cell phones before the school bell rings in the morning, during break, and after school. Those are the less restrictive
You are
measures.
saying that the school should have changed the code of conduct, not that they should have considered less restrictive means to implement the current code of conduct. Okay. I'm not sure if any of my colleagues here have any questions for you, and we will hear questions from them, and then we will allow you to hand over to the Leonard friend that you have got.
I do have one question. It is Judge Saunderson. I would like to just hear from counsel. I mean, I heard the very passionate arguments, legal arguments. I'm curious, are there any other moral or any other arguments that would support your case? And I am, apologies, I am in particularly thinking about the huge problem in South Africa with bullying, online bullying, you know, videos being taken of learners at school, and with that absolute freedom to use cell phones, not cause further problems. Thank you.
Answering your question, Justice, through correct usage and monitoring by the educators, cell phones may be used to download educational apps and record lessons to ensure that quality education is sought after.
Thank you.
Thank you.
Justice Ozar?
Thank you. I'm fine for now. I'll reserve my questions for later. Thanks.
Thank you. You may hand over. We may hear from the second counsel for the applicant.
May it please the court. My name is Sano Stanop, as my co-counsel has said, and I will be dealing with Section 17 and Section 29 of the South African Constitution. Section 39 of the South African Constitution states that the court must consider international law. In this case, we present to the court the International Convent on Civil and Political Rights, the ICCPR, that states that the right to peaceful assembly shall be recognized, and no restriction shall be placed against practicing these rights if an individual is unarmed. In the case of Satao and others against Gavas and others, it was clearly stated that any person who is unarmed has the right to go out and protest with others, to assemble, to demonstrate, to picket, and to present petitions to others for any lawful purpose. We submit that the applicants were unarmed during the protest and no violence was used. They had every right to protest.
Counsel, you make a very good argument there. However, allow me to just engage with you on this a little bit. In Satau, you acknowledge that the court does, as a matter of fact, say as long as the people are unarmed. And what the interpretation of unarmed, I think, which I have to clarify for you here, is in terms of Satau, when you look at paragraph 53, I think, and when you look at the ICCPR or the ICSCR in general, or other international covenants governing the right to peaceful assembly, is that the right is given to all individuals to assemble, to demonstrate, to picket, to all that, but it is qualified by peace, which means you cannot exercise the right in a way that is not peaceful. In this case, there was violence that erupted as a result of these demonstrations and assemblies. There were bins that were burned by the school gate close to the teacher's car park. And later on, we also find out that there is an administration building in the school that is set alight. So basically arson. So can we say that these demonstrations were indeed qualified by peace as required by domestic and international law?
The protests were peaceful, hence, when you look at the thing of the arson, there were no culprits that were identified from those things. So we cannot crucify the applicants for the acts of vandalism that took place there without having a concrete evidence proving that.
Okay, so let's set that one aside. With the bins that were set alight by the teachers' car park, what about that?
Even there were no culprits that were identified from that scene too.
Okay, if you say so. But is it not reasonable to infer that since it was these 6 students who were suspended, who initially commenced with, this enthusiasm of demonstration and picketing and all that, is it not reasonable to infer that even in all these other instances, it was their conduct that led to these things, and therefore they were there, they were the participants, they were the leaders of these demonstrations and pickets, in particular because all the other students really had no interest in picketing until they started, with the movement, because the other students were not suspended. They were suspended. They had an interest in petitioning against the school. So is it not reasonable to believe that they were the people who were responsible for the violence that erupted?
No, anyone could have set the school on fire, or rather, static electricity could have taken place in the school. And the effects of that, the applicant gave our students an idea of protesting should not be taken as a bad way, hence, and these other students were not fighting against suspension, they were fighting for their own purposes against corporal punishment. Anyone who restricts children from practicing their rights to participation, expression, and peaceful assembly, especially if those children are hosting an entirely peaceful protest, may be subjected to criminal sanction. We must admit that protesting gives voice to the powerless. In some instances, protesting is the only mechanism that is available to fight against injustices and express legitimate concerns. Section 12, subsection 1 of the Regulation of Gathering Act, number 205 of 1993 states that if a gathering will be attended by 15 or less people, then there is no need to give a notice. However, if a gathering will be attended by more than 15 people, you are not required to give a notice. In this case, the protest of the applicant started with 6 people, and when the time went by, more people joined in. This justifies the reason of the applicants not giving a requisite notice, and hence they had no idea of people who were going to join in the later stage. In the case of Nungwana against the state, the court stated that a convener's mere failure to give a...
If I may, the fact that they were not aware that people would join, does that mean they are excused from complying with the notice requirement?
Yes, because their own protest consisted of 6 people and not more than 15 people.
No, but people started to join in. We have instances where there were more than 40 students, and another instance where we had about 100 students, which means now, we are dealing with an instance where notice must be given. So are they excused from giving a notice merely because they did not anticipate people to join in?
Yes.
So after they had the one where there was 40 people, could they not anticipate that they would still have more in the next one where they had 100 people? So the first one they had, it was just the 6 of them, and it was peaceful and everything, I agree with you. But the second one, there was about 40 people, and the third one, there was about 100 people. Couldn't they foresee before they had their third one that since they had a lot of people in the second one, they would have a lot in their second one as well?
It's called that they had no idea about the law or rather the regulation of gathering act, and in the case of Nungwana against the state, stated that the convener's mere failure to give a notice of an intention of holding a gathering should not be criminalized. Adding to that, it was also stated that Section 12 of Section 1A of the Regulation of Gathering Act constitutes an unjustifiable limitation to the rights of peaceful assembly. Can I proceed? Okay, thank you. Also, the protest of the applicants was spontaneous, therefore it was not a criminal offense to join a protest where notice was not given. The right to basic education was violated, hence learners were over-suspended. We believe that education is the most powerful right amongst others that improves the learner's personality, talents, and physical abilities. Section 9 of the South African Schools Act number 84 of 1996 states that the SGP of a public school may, after a fair hearing, suspend a learner from attending school as a correctional measure for a period of not longer than a week. We submit that the applicants were suspended for a period of longer than a week. This proves that the disciplinary hearing was not conducted in the manner that is contemplated in Section 8 of the South African Schools Act number 84 of 1996. We cannot expect learners to succeed in life if we keep on denying them the right to basic education. Adding to that, the school did not send suspension notice to the parents of the learners that states the reasons of why a learner is being suspended, and no appropriate arrangements were made for provision of schoolwork for learners in the period of suspension. The applicants were immediately suspended for the rest of the year, meaning that they were not given the opportunity to be heard. We are against that, hence we believe that the applicants were not endangering anyone's life, so they had the right to be heard. In conclusion, our argument was based on the facts of that the applicants were unarmed during the process and no violence was used. Adding to that, their suspension was not according to Section 8 of the South African Schools Act number 84 of 1996. Counsel for the applicant therefore requests this honorable court to declare that the High Court was incorrect in finding that the applicant's rights stated in Section 14, 17, and 29 of the South African Constitution were not violated, and that Section 4 of the Schools Code of Conduct is not unconstitutional. Secondly, to declare Section 4 of the Schools Code of Conduct and the SGP's decision as invalid and unconstitutional. And lastly, to declare the suspension as illegal, hence the disciplinary measures went beyond what was allowed by the South African Schools Act. If it pleases the court, may I please descend and let my honorable friends to state their case.
Yes, counsel, thank you very much. The respondents, we may hear from you now.
As the court pleases, my name is Nsmcc. I appear as the first counsel for the respondents. I appear together with my co-counsel, Nsmcc. There are two issues that lie before this court. The first being whether the application of Section 4 of the Schools Code of Conduct is not unconstitutional and does not violate the learner's right to privacy and basic education in accordance to Section 14 and 29 of the Constitution. The second issue is that the SGP's decision is not unconstitutional and does not violate the learner's rights to peaceful assembly in accordance to Section 17 of the Constitution. As the first counsel, I will be attending to the first issue and be arguing for 10 minutes. My co-counsel shall proceed for 10 minutes and attend to the second issue. The justices, I'll humbly submit that paragraph 4 of the fact states that after a consultative process, the SGP introduced a code of conduct regulating the use of cell phones at school. Therefore, I humbly submit that the Schools Code of Conduct is constitutional because it was promulgated with the participation of the SGP, the learners, educators, and parents. It is aimed at instilling discipline in school and ensure a purposeful school environment. It also ensures the safety and protection of the learners. If the school was to allow these 6 learners to disregard the Schools Code of Conduct, the purpose of a discipline school will be defeated. And this learners' behavior will set a procedure of ill-disciplined learners. The school had to take measures to prevent such an issue from escalating. With that being said, I humbly submit.
Sorry, Ms. Mchali. what is really the purpose of this provision? Because from what you're saying now, it seems like the school is taking a very punitive approach rather than a corrective approach, in a sense that you kind of arguing that you had to make an example of them. You had to, so that other learners do not behave the same, particularly on these facts where the learners were not actively using their phones. You did a search and seizure and you found the phones, some of them even off in their bags. Could we say that the actions of the school were justified in where the facts on the facts itself? The phones, some of them were off, none of them were being actively used, and linking that with what is the aim of this section 4 of the Code of Conduct, and also existing jurisprudence about how schools should approach this issue of Code of Conduct. I mean, we have the Antony judgment and some other ones where this issue of punishment versus discipline is very central, and I'm concerned that the school seems to be arguing that, well, we have the Code of Conduct and we had to make an example of these learners so that others don't behave the same way. Is that really an approach that is in line with the constitutional, the Constitution, and protecting and considering the rights of these learners to education?
Thank you for your question, Your Justice. May I please refer you to the matter between Head of Departments, Department of Education, Free State Province versus Golcom High School, the case of 2014, number 2028, paragraph 58, where it is stated that a code of conduct must be established in order to instill discipline in school and for the school to have a purposeful environment. And that the code of conduct must be dedicated to the maintenance and improvement of the quality of the learning process. Yes. If I may refer you to page 1 of the hypothetical case, it is stated that this school has a long history of ill discipline. Yeah. And it is mentioned.
I may quickly just interject a bit there with a question of some sort. I think I will follow with the question that my learned colleague was basically asking you, and you have justly referred us to the correct judgments in Velcom. However, even in that case, the court concerned itself particularly with positive discipline when it looks at whether or not there is compliance which would justify a punishment or a sanction, right? But the court is very clear that it rather desires that we positively discipline the students by giving them, additional work, detention, etc., rather than suspending them, which would be a violation of their right to education. And in this instance, you have suspended the students from the school, which means you are now no longer complying with positive discipline. You are now punishing them. There is some sort of a sanction, which means you are acting outside the ambit of what you are allowed in terms of the very same judgment that you are citing to us, which is Velcom. So how do you then cure that gap here?
Thank you, Justice. I humbly submit that implying positive discipline on these learners was achieved by confiscating their cell phones. And as far as going to the point of suspension, Ms. Koza reconsidered her decision, because in paragraph 12, it is stated that the principal called a meeting to engage the learners of the parents, and she was willing to resolve the matter amicably and now suspend the learners for the period of 7 days.
But she's still suspending the learners. Was it not just enough to take their cell phones? Why suspend them?
Thank you, Your Justice. However, it is for that school to see that it is best for these learners to be suspended, because even them, they agreed for a need for greater discipline before the school's code of conduct was implemented.
But how is this in the best interest of the learners? They're all children, and in accordance with the Constitution, the best interest of the student of a child must prevail in every matter concerning a child. So how, in this case, do you show that it was in their best interest that they do not receive an education?
Thank you for your question, Your Justice. If I may refer you to the matter between Moodley versus Cadmont School and others, the case of 2019, number 281/18, held at the Constitutional Court, where it is stated that although Section 58A, subsection 4 of the South African Schools Act limits the right to equality and dignity in light of the rights that it seeks to protect, the right to basic education, the limitation is reasonable and justifiable under Section 36, subsection 1 of the Constitution. It's concluded that the purpose of the limitation brought about by the prohibition in Section 58A, subsection 4, to avoid any adverse effects that could be caused by the attachments of schools' assets, thereby protecting the right to basic education and ensuring that the children's best interests are offered paramount importance. It is for the best interest of the...
Miss Charlie, sorry about that. Breathe a bit. How do you protect the best interests of the learners, particularly the applicants, without hearing them? Because one of the big issues is the fact that they were suspended without a process where they were afforded an opportunity to state their case. And we have a rich jurisprudence from the Constitutional Court about hearing the learners. Even the Pillay case that has been referred to you guys, in that case, one of the things that the Constitutional Court said was that it would have been nice to hear how Ms. Pillay was affected by this issue of the no stud. So, and procedural fairness is very important. So the applicants are saying, well, you suspended us immediately, you didn't hear us. And how do you determine best interests of learners that you haven't heard? You haven't heard whether the ones who had the cell phones off, were keeping them until after school so they could call the school driver to come and pick them up or whatever. How do you justify that? Not having given them an opportunity to argue their case as to why they had the cell phones.
Thank you for your question, Your Justice. It is afforded the child's best interests have been attended to in this matter because by confiscating their cell phones, they're being taught discipline. And as far as the set of facts are concerned, the school had a long issue of discipline while learners used to engage in social media during the times dedicated to teaching and learning. And Mr. Nsmcc complained that it was hard to teach under such circumstances. And the right to basic education was not effective as it was not maximized. Your Justice says, furthermore, I would like to submit that the right to privacy affords a greater intensity of protection to personal activities within the center of the home. But where individuals engage in criminal activities, such as education, the intensity of this right diminishes or it is not taken into consideration.
Sorry, Ms. Mchali, are you referring to the criminal activity or are you referring to the protests, not the cell phones?
I was referring to thank you, Your Justice. I was referring to the submission made by the first counsel for the applicants when she stated that they do not want the learner's right to privacy being limited. Whilst the right to privacy is not absolute, as it can be limited in terms of Section 36 of the Constitution. Furthermore, Your Justice, I would like to state that the SGP's decision is not unconstitutional. As Ms. Khoza did send a meeting, the learners should come to school to resolve the matter amicably. However, it was unsuccessful, and this is not in fault of the school, but the learners, because they are the ones who protested and blocked the school's interest and prevents from this meeting to take place. I have come to the conclusion of my arguments. As it may please the courts, I request the leave of this court to hand over to my co-counsel as she will further elaborate.
Thank you. You may hand over to your co-counsel.
As it may please the court's justices, for the sake of the record, my name is Nsmcc. I appear as the second counsel for the respondent in this matter. Since my learned co-counsel has dealt with the first issue, I will proceed on settling the second issue that the SGP's decision is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. Justices, the school followed the Gathering Act number 205 of 1993, It is this very same act which states that people who wishes to assemble must get a permission. And the regulation of the Gatherings Amendment Bill seeks to prohibit gatherings and demonstration outside the school as well as other institutions of learning and care such as children's homes and houses of safety where there are minor children. The proposed amendment is to protect minor children from protests that sometimes turn violent. I would like to draw the court's attention in the matter between Mlungwana versus the state held at the Constitutional Court number 32/18 on 2019, where the Constitutional Court stated that people must get an authority and a notice before they could assemble. Furthermore, on submission,
Ms. Tangazela, do children have the right to protest and to assemble themselves? Because you just mentioned that the approach is to protect minors, children, where potentially people are gathering to protest. But what do we say about the very children's right to protest? You know, we have constitutional rights. Do they also hold the right to protest, such as they did in the matter before us today?
Thank you, Justice, for the question. The answer to your question is yes, but before they protest, they must get an authority and notice, as the Constitutional Court stated in the matter between Lungwana versus the state on the Constitutional Court case number 32 on 2019. Furthermore, on submissions, Justices, Section 20, subsection 1A of South African School Act number 84 of 1996 states that the SGB of a public school must promote the best interest of the school and strive to ensure its development through the provision of quality education for all learners at the school. Justices, the school did not infringe on the applicant's right to privacy in terms of Section 14 of the Constitution. If I may refer you to the guidelines of the consideration of governing bodies in adopting a code of conduct in terms of Section 8, subsection 3 of South African School Act number 84, 1996. It was stated in sub-regulation 4 that as much as the learners have their right to privacy, however, a principal or an educator may set the learners based on his or her reasonable suspicion, followed by the search methods.
Counsel, I just want to specifically look at the constitutionality of the clause, Section 4 itself. Let's not even consider the conduct of the principal with the search, the seizure, and the suspension of the learners. Let's look at Section 4 itself. Sections 14 of the Constitution is clear that every person has the right to privacy, which includes the right not to have, 1, their property searched, and 2, their possessions seized. In our case, there is a search of the learners' bags, there is a seizure of their mobile cell phones. Doesn't this seem to you as a direct violation of the constitutional provision protecting the right to privacy? Especially in view of the fact that the learners were not using the cell phones in class and therefore they were not disturbing the learning activities. A note of the fact that the cell phones cannot be considered to be dangerous weapons for the safety or the health of the staff or the learners. And so it would be unjustified for the school to suspend the learners in any event. So doesn't that provision seem to you as if it's unconstitutional?
Thank you, Justice, for the question. As my learned co-counsel earlier submitted that the right to privacy is not absolute as it may be limited in terms of Section 36 of the Constitution. Justices, if I may refer you to the hypothetical case where it is stated that after a consultative process, the code of conduct is implemented, meaning it was practical. If the learners weren't happy about this policy, they should have consulted with their representatives. And also, Justices.
Counsel, but I think my question is still not answered. My question goes to the policy itself, the code of conduct itself, not its implementation. Is it constitutional? Can we say that the code of conduct is indeed constitutional in view of all the things that I have, indicated to you? Can we say that the code of conduct is constitutional?
Thank you, Justice. The answer to your question is yes, as there was a consultative process before the Code of Conduct was implemented.
So, Council, if you and I enter into an agreement, I'm your educator, you are my student. If we enter into an agreement that should you get any wrong in any of the work that I give you, I should whip you with a shambok. And I give you an assignment and you get a 30% out of 100, and I give you 70 whips. But we both agreed and we had witnesses and they all agreed that we agree. Does that make my conduct and our agreement lawful, irrespective of your right to human dignity in accordance with the Constitution, firstly, and secondly, in respect of the fact that corporal punishment is not allowed in schools? Does that mean that merely because we agreed and we had witnesses agreeing to it, it's lawful, it's constitutional?
Yes, Your Justice. According to South African School Act, punishment is a corrective measure or a penalty inflicted to an offender who has to suffer the consequences of misconduct to maintain the orderly society of the school. If I may proceed, Your Justice, Section 36A states that the nature of the right has to be considered as far as limitation is concerned. Now, in this matter, one must be wondering if there was no other way to deal with this matter rather than suspending these learners from the school. Justice, I would like to refer to paragraph 4 of the set of facts stating that the use of cell phone by the learners on school premises shall at all times be prohibited. Any learner that is found in possession of cell phone shall have that phone confiscated and may be suspended. I humbly submit that these learners were quite aware of this policy and its consequences, as sub-regulation 5 of South African School Act states that the rules should make the provision for the fundamental fairness and a fearing. Ignorance of this policy is not an acceptable excuse, as the learners are expected at all times to adhere to the school code of conduct. Justice, if I may refer you to the matter between Ministry versus Interim Medical Council held at the Constitutional Court 1998, it was stated that the more public an undertaking would be any corresponding claim to privacy be in respect of the activity. Justice, according to Section 9, subsection 1B of South African School Act, it states that when interpreting the Bill of Rights, a court must consider international law. The United Nations International Covenant on the Civil and Political Rights states that no restrictions may be placed in the exercise of the right to assembly other than those that are imposed in conformity with the law and which are necessary in the democratic society in the interest of natural security, public safety, public order, as well as the protection of the rights of others and their freedom. Justice, in my conclusion, Counsel for Respondents submits that the SGP has not violated the learner's rights in terms of Section 17 of the Constitution or infringed on the applicant's right in terms of Section 14 of the Constitution, or the decision to suspend these learners from the school did not infringe on the applicant's right to basic education in terms of Section 29 of the Constitution. Counsel for the respondent respectfully requests this honorable court to declare that the court was correct in finding the application of Section 4 not unconstitutional, as there was no violation of the applicant's rights in terms of Section 14 and 29 of the Constitution, and the decision to suspend these 6 learners not unconstitutional, as it does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution, and for further alternative relief that the court deemed fit, and this appeal be dismissed with cost.
Thank you very much, Counsel. We shall now hear a rebuttal from the applicants.
My justices, I must say that when the applicants are agreeing to greater discipline, that doesn't mean that they were agreeing that their rights must be violated. The agreement in the Code of Conduct didn't mean that they also agreed that their right must be violated. And also, Section 12, subsection 1A of the Regulation of Gathering Act was declared as an act that constitutes an unjustifiable limitation to peaceful assembly in the case of Mlungwana against the state, even if corporal punishment is a correctional measure. However, we must acknowledge that it is forbidden by Section 10, subsection 1 of the South African Schools Act. Other than that, I think we are set and we are waiving the rebuttal.
Thank you very, very, very much, counsel for the applicant. Thank you, counsel for the respondent. I will allow my fellow colleagues, Justice Sanderson as well as Justice Oza, to basically give some brief feedback, and we can proceed to our next sessions, and I wish you guys all the best. I will start off with Justice Oza. Justice Oza, perhaps just a brief commentary to the teams. Thank you.
Thank you so much. Well done to all of you, obviously, for getting this far. I think your arguments were very well prepared. I think there's few people still struggling with that issue of questions. Please try, when you get questions, to answer as clearly as possible, because that's a way of ensuring us as judges that you are engaging with the application of the law to the facts. So again, I would urge you to really think about that as you progress through the day. But otherwise, well done, and you managed to deal with the nerves very well. So yeah, great for getting this far. Thanks.
Thank you so much. Justice Sanderson, over to you.
Thank you, counsels. I would just almost echo what Judge Oza said. I think that congratulations are in order for making it this far. In addition to what she has said, I would also urge you to maybe just in your way of presenting, try to not rely on notes too much. I know it is nerve-wracking, but yeah, just speak from the heart. But well done to all of you, and all the best for the rest of your rounds.
Thank you. And I think I have judged both of you somewhere, somehow. And I think you all know that for me, the biggest comment is really, do not be intimidated by the fact that I ask a lot of questions. Your judges will generally also engage with you in the quarters and the semis. And so just always remember that a moot is a conversation between you and your audience. So whenever we are asking you questions, we are just intrigued by the things that you are saying, and we think they are worth pursuing in a conversation because we just want to see how far you can go about them. Otherwise, I wish you guys all the best, and I hope to see you guys in the next rounds moving forth. And with that being said, you may exit the session and we can have the next participants in. Thank you. Bye-bye. Okay, we have both teams for the session here. Team 121 and team 202, it seems. Let me just quickly confirm who is the applicant and who is the respondent, because it seems they both say they appear as the applicant. 121 is the applicant and 202 is supposed to be the respondent. Team 202, I will rename you for respondent. There you go. Teams, welcome. If I may kindly request the applicant and the respondent teams to use the chat function box to indicate the name of the first oralist, the name of the second oralist, the amount of time that the first oralist will be taking, the amount of time that the second oralist will be taking, and the amount of time the applicants would be reserving for rebuttals if they're not waiving their rebuttal time. I'll give you about a minute to finalize that. Please indicate, I see the applicant team has commenced. Please indicate who is the first oralist, who is the second oralist. It is important that we understand the order in which you will be speaking as well. Thank you very much. I'll give you about a minute to finalize it, and then we can begin with our round. Thank you, teams. I see you have done as requested. Kindly note that I will be keeping track of your times. And so you will have to basically just look at me once in a while to check how far you are with your time. Team applicant, Refumelo Mhlanga, you may proceed with arguments for the applicant. Thank you.
Okay, am I audible?
Yes, you are audible. You may continue.
Okay, I'll start in 3, 2, 1. Chief Justice, your justices, my name is Rufumela Mhlanga, and on my left, I'm with my co-counsel, Kabela Talent, and will be appearing on behalf of the applicant. I'll be speaking for 7 minutes, and my co-counsel will be speaking for 11 minutes, and we'll be reserving 2 minutes for rebuttals. In today's court, as the applicant, will be humbling ourselves to bring you 2 core submissions. The Section 4 of the Code of Conduct has violated the learner's right to privacy and education, respectively. And secondly, we'll be submitting that the SGB's decision was unconstitutional as it violated the learner's right to peaceful assembly. Would the court like any brief summary of the facts? Okay, thank you. The critical question before the court is whether Section 4 of the Code of Conduct is constitutional and whether its provision violates the learner's right to privacy and education, and furthermore, the SGB's decision, if it's justified as it has violated the learner's right to peaceful assembly. In response to this question, the applicant submit that Section 4 of the Code of Conduct violates the learner's right to right to privacy and also the right to education, and furthermore, the SGB's decision was unconstitutional as it violated the learner's right to peaceful assembly. Therefore, the counsel for the applicant will be arguing in line with Section 14 and 29 of the Constitution and the case of V. Anthony Body Settlers High School, that Section 4 of the Code of Conduct is unconstitutional as it violated the learner's right to basic education. Coming to my first submission, whether the right to privacy has been violated by Section 4 of the Code of Conduct. We submit that Section 4 of the Code of Conduct is actually unconstitutional as it violated the learner's right to the right to privacy. Section 4 of the Code of Conduct states that the use of cell phone, whether on or off on the school premises, shall at all times be prohibited. And we submit the fact that this is what the School of Conduct has actually have stated. This is a direct violation to Section 14, subsection C of the Constitution, as it gives everyone, including the school learners, the right to not be violated any at all, and the confiscation of their possession to be not seized any at all, which is actually
interject a bit, then ask you a question. I think you're raising a valid point insofar as you were raising that indeed the students have the right not to be violated or their privacy violated. But when we are dealing with the right to privacy, it is also quite important that we consider that the right is quite not as protected when we are in public spaces. So for example, this court in its Mystery versus Interim Medical Council of South Africa decision basically said that the right to privacy is not strong, or the protection to the right is not very strong when we are dealing with public spaces, public institution, public activity, and so forth and so forth. The right is rather strong when we are dealing with the private realms, personal realms of an individual. But the moment that a person is in a public space, engaging in a public activity, the protection of that right is quite limited. So would you not say that this right has been justly limited in this case?
Okay, we can say that it was actually limited, but in terms of understanding this was too harsh for the learner without recognizing the full spectrum of the limitation. The limitation was not justified at all because it did not recognize the learner's best interest in this instance, as we can refer to Section 28, subsection 2 of the Constitution, which states that a child's best interests are paramount importance in every matter concerning the child. So they did not look at the interests of a child, where interests of a child need to be obligated and still be paramount in every matter concerning a child, and everywhere we are in most instances. So let's look at
Mr. Mhlanga.
Yes.
Sorry about that. Just a quick question. Does the fact that Section 28(2) says that the rights of a child are paramount mean that the rights of a child cannot be limited?
Yes, there can be limited, but the best, okay, let me read it. A child's best interests are paramount importance in every matter concerning a child. But certainly the interest of a child needs to be considered, not the fact that they cannot be limited, but there's a need, the limitation must be justified to the fact that it accommodates such right. I hope I've answered your question, Your Honor. So we submit that a phone is actually a potential risk on the school premises as the paragraph 1 proves that, saying that, okay, yes, that the use of cell phone in the school premises at all times was actually not doing better to the school premises, but actually harming the school premises. But the problem comes here that, okay, a phone can be used for many instances. It can be used for you to learn at home, doing many things that are correspondent to education. But certainly we have to understand the fact that there are other options that can be opted in to just justify justify a code of conduct that is going to be certainly the very same way, or actually fitting to what actually they want to just ensure that cell phones they're not coming with cell phones on the school premises. So the examples that we can give you is like teaching continuously, the learners saying that, okay, you don't need to learn about the right and the bads of a cell phone, saying that, okay, a cell phone is bad in this way, and also finding them certainly if there's if you find it that, okay, you don't want to teach them on the basis, but you just say that, okay, we're going to fine you 500 if you come with the phone, rather than just actually violating the learner's right to privacy as not taking into consideration the best.
Who's going to pay the 500, Mr. Mhlanga? Is it the learner or the parents?
Okay, the parent will be paying for the money.
And how does that correct the behavior of the learner? Because you're trying to let the learner learn something, and is it really, again, now you're opening a can of worms? Is it fair to now start imposing those kind of fines where you have indigent learners who will now have to be paying because they violated the laws? I think you need to really reflect about that.
And in addition to that, how is that corrective, so to say, or how is that disciplining the learner? Sounds to me more like you are disciplining the parent. You are punishing the parent. So where does the learner then fit? When you impose such a sanction, we are meant to ensure that we discipline the learners, but here the case is that you are actually imposing the fine on the parent and not the learner themselves. So how do we fill this gap?
Okay, certainly it was just an example that was giving up that the school can opt in, but certainly to answer your question directly, we think the school can, we have to understand the fact that if we coming up with fining you at the first place, that can be something that can punish the parent, and the parent will be just doing what is actually obligated to to discipline the child. So the responsibility is left out to the parent to ensure that you're actually paying that money. And actually paying that money is not, that we love money as people, and that seeing the fact that our money goes to a certain place, we won't want to see our money going to the wrong place. We want to see it using in a very good way, so that we ensure that, okay, my child should not come with a cell phone at the school premises. I hope I've answered your question, Your Honor. So this court does need to review, we need to recognize the fact that in PLA, they ruled the fact in paragraph 98.
Unfortunately, yes. Your time is up. And so I will give you an extension of 20 seconds to just wrap up what you are about to say.
In 2008, MEC of Education at KwaZulu-Natal and others, PLA, ruled the fact in paragraph 98 that even though discipline and legitimate goes on the school premises, the learner's interests need to be taken into account in every matter. So in today's court, we need to understand we take into correctiveness the failure to take into account the interests of a child, which amounted to violation of the learner's right to privacy. So counsel for the applicant prays with the court that they need to take into interest the learner's best interest. Thank you for your time. I would like to take over to my counsel. Yeah.
Can I start? Chief Justice, the Justices, my name is Talent Mkavela, as my co-counsel Mhlanga Fumelo has mentioned, and we both appear on behalf of the applicant. So today we have 3 critical questions. 1, whether Section 4 of the School Code of Conduct violates the right to privacy. 2, whether it violates the right to education. 3, whether the SGP's decision violates the learner's right to peaceful assembly. So as the second oralist, I will be dealing with the right to education and the right to peaceful assembly. So I'll now proceed to address the second issue, that is on whether Section 4 of the School Code of Conduct violates the right to peaceful, the rights to education. Now, Your Honor, can we please turn our attention to paragraph 4 of the facts that states, or rather speaks, about the provisions of the School Code of Conduct. Now, what does it say? It says, and I quote, "The use of cell phones, whether on or off, by learners on the school premises shall at all times be prohibited. Now, any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." Now, we have to understand what part makes this part of Section 4 of the School of Conduct to be unconstitutional. Simple. It is that it permits the suspension of learners that are found with cell phones. Mindful of paragraph 58 in and of Department of Education, Free State Province versus Welcome High School, and another, Section 28, subsection 2, and Section 36 of the Constitution, we submit as the counsel for the applicant that the Section 4 of the School of Conduct permits a severe punishment, which means that it's a harsh punishment for the learners and is therefore inconsistent with the aims of the School Code of Conduct itself and the Constitution. Now, Your Honor, this court in its 2002 Antonio versus Governing Body of Settlers High School ruled at paragraph 17 that even in a case whereby rights are prohibited or rather limited with the aim of promoting positive discipline, all the factors that are listed in section 36, subsection 1 of the Constitution must be taken into account. Now, in that case, as it is in this case, we argue and reason with the court that the failure of Section 4 itself to consider that factor that is listed in Section 36, subsection 1E to take the less restrictive means simply means that it is unconstitutional and it does not consider less harsh means to create discipline. We are saying that this is not in line with Section 36, subsection 1E of the Constitution, which finds that when the rights are limited with the aims of promoting positive discipline, then less restrictive means to achieve the purpose are supposed to be taken into account. To further reason with the court, we argue that such suspension, Your Honor, declines the learners to prepare what is best for their success. Because when you suspend them for the whole, it simply means that these learners will be unable to learn and they will have to repeat the grade, which is a bad thing and it's not in the best interest.
That's not what the facts say. The facts are very clear. The learners were suspended for the maximum period. In accordance with the South African Schools Act, the maximum period which can be given by the SGB is 7 days. Should we not make the assumption that the learners were suspended for 7 days, not more than 7 days?
Your Honor, when it was said that the school governing body calls an urgent meeting and decides to suspend for the maximum period, the learners were arrested. They are now referring back to the suspension that they gave Sectel because it is that maximum period that is for 1 year. They were no longer acting.
If I may quickly there, I need us to be able to distinguish certain things here. I need us to be able to distinguish Sfiso Tele and the 6 applicants.
Yes.
And I also need us to be able to distinguish the events that took place here. We are not dealing with Sfiso Tele's suspension here. We are dealing with the applicant's suspension. The facts say to us they were suspended for the maximum period. With Sfiso Tele, the facts are clear, he was suspended for the whole year. But with the applicants, it says they were suspended for the maximum period. The maximum period allowed by law is 7 days. Should we not assume that they have been suspended for 7 days, as that is, by law, the maximum period?
Your Honor, we have to understand that according to paragraph 6 of the facts, the school principal suspended the learners for the rest of the year. And this is still the suspension that is still being held at this point. So we have to understand that that one is taken into consideration, not the 7 days one.
Counsel, I have to interject you again. Yes. Let's go to the fact. I need us to go to the fact, right?
Yes.
So the facts say to us, the school governing body calls an urgent meeting and decides to suspend for the maximum period the 6 learners who were arrested. The facts are clear. The learners were suspended for the maximum period when we are dealing with the 6 applicants. However, when we are dealing with Sfiso Tele, we know that he was suspended for the whole year, for the remainder of the calendar of the year, for the rest of the year. How do we see that? The facts say Sfiso undergoes a disciplinary hearing, resulting in his suspension for the rest of the year. And I'm doing this because I need us to be able to distinguish between the two, which means now we have been able to distinguish between the 6 applicants who were suspended for the maximum period and Sfiso Cele, who was suspended merely for the rest of the year, right? So now let's focus on the 6 applicants. In accordance with the law, the maximum period is 7 days. Should this court not believe that the applicants are suspended for the maximum period, which is 7 days?
Your Honor, I now agree with you that it is 7 days, but we still have to understand that if the SGB is now acting in accordance with the South African Schools Act, they still have not, they still have not satisfied all their obligations in the South African Schools Act, because you have to understand, Your Honor, it was said that there is also a need for a fair hearing, which in this case was not given to the applicant. So if the respondent,
is there a need for a hearing in instances where the rule is clear about a sanction that must follow? So where the rule is clear that if you do this, if you violate this rule, this is the sanction that will follow, you will be suspended. Do we still have the obligation to give the guilty party a chance to be heard?
Yes, Your Honor, yes. There is still a need for a fair hearing, because it is said in the section 4 of the School of Conduct that the learner may be suspended, meaning that there's a possibility that the learner may not be suspended, and therefore there's a need for a fair hearing, Your Honor. Because if there's no fair hearing, it simply means that the learners won't get a fair chance, because we have to understand this thing. The learners were having different situations. There were 3 learners who their cell phones were on. There were other 3 learners who their cell phones were not on. So therefore, we need to distinguish, because there are different situations, and there's a need for a fair hearing, because it is important, Your Honor. So can I proceed with my arguments? Proceeding. Now, Your Honor, the court thus needs to review the High Court ruling as it clearly enumerates to limit the right to education. This is therefore makes section 4 of the School Code of Conduct unconstitutional. Now, in Antony, this court found that the failure to meet the factors that are listed in section 36, subsection 1 of the Constitution by the SGB amounted to a violation of the learner's right to education. And as such, we as the counsel for the applicant praise for this court to similarly hold that the failure of section 4 of the School Code of Conduct to adhere to the requirements that were listed in section 36 means that section 4 of the School Code of Conduct is unconstitutional and amounts to a breach of section 29.
I'm interested in your reference to Antony. Exactly where did Antony say the things that you said Antony said?
Your Honor, it was stated in paragraph 19 of Antony. They say that because the failure to meet all these factors that were listed are they're supposed to be taken into account. It was given in the page we were supposed to refer to, that is the judge bench guidelines. It was stated in Antony there. So can I proceed, Your Honor?
In paragraph 19, you say?
Yeah.
So the court said?
Your Honor?
You said paragraph 19 of Antony.
17. Yes, Your Honor. Your Honor, it is important.
Numbers, 17 or 19?
It's 17. It's a mistake, Your Honor. I'm legally imprecise with this.
And when you say in paragraph 17?
Your Honor, it says that the question should be asked in this regard whether or not the prohibition is aimed at promoting positive discipline and whether or not non-compliance, therefore, justifies the punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance.
So would you say in this case there was positive discipline by suspending the learners? Don't you think that is positive discipline? I mean,
Your Honor, it's actually not.
Your learned friend was telling us that we could, for example, fine the parents, but that is not positively disciplining the students. So isn't taking the property that belongs to the students and suspending them in that regard positive discipline for the students?
Your Honor, taking the property and suspending them for 7 days is not positive discipline, because when you suspend them, as the council, we have to ask ourselves, what will the learners go and do at home? Simple. If they're not going to receive work, it simply means that these learners will no longer do the work, and therefore it is not in the best interest of the learners, and they don't learn any discipline when they're suspended. Your Honor, it seems as if time has run out. Can I please get 1 minute to sum up the peaceful assembly point?
Council, you still have about 50 seconds. It should be sufficient.
50 seconds, okay, fine. Sir. Your Honor, proceeding to address that issue on the issue of peaceful assembly. Your Honor, on this issue, we are clear that the respondent cannot limit this right, because there's no way that they justified or they fully dealt with all these factors that were listed in section 36 of the Constitution. We are saying, Your Honor, that because the respondent failed to qualify with the factors that were all listed in section 36 of the Constitution, it makes the decision of the SGB to be unconstitutional. However, Your Honor, we do agree that the learners did do the wrong things when they staged a protest where they threw dustbins into the road. We do agree with that. But we are saying that the suspension of 7 days for the learners by the SGB, thank you, Your Honor.
Thank you very much. We will now hear arguments from the first agent for the respondent.
Yes, Your Honor. This is really,
Atandile.
Justices. Today, I'll be touching on the first issue, which is whether or not Section 4 of the Schools Code of Conduct is not unconstitutional, as it does not violate the learner's rights to peaceful assembly and education in terms of Section 14 and 29 of the Constitution. And my co-counsel will be addressing the second issue, which is whether or not the SGP's decision is not unconstitutional, as it does not violate the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the Court of Justices, I'd like to make my first submission under the right to privacy, and I have one argument under that. Your Justices, we are aware that privacy is a fundamental right, but it is not an absolute right. With that being said, your Justices, we allow privacy to be limited under activities such as surveillance and can only be justified when they are prescribed by the law, necessary to achieve a legitimate aim and proportionate to the aim being pursued. Your Justices, with the use of Section 36 of the Constitution, which is the limitation clause, we, as the respondents, have limited the learners' rights to privacy because there was a reasonable and justifiable cause to search these learners, because there was a valid suspicion when Sfiso Cele's phone fell out of his pocket. This then raised an awareness that actually learners do bring cell phones to school. And so when we were searching them, your Justices, we wanted to make sure that Section 4 of the Schools Code of Conduct was being followed by the learners to maintain respect in the school grounds. With that, your Justices, we submit that coming from the history of Mjondolo Combined School that made learners bringing cell phones to school, not bringing them for proper reasons, and not using them in a correct way, just like being on social media. And that disturbed the learners, not only in their academics, but as well as in their respect, because academics go hand in hand with respect.
And here I want to specifically ask you about the legality, the constitutionality of Section 4 of the Code of Conduct. But I will draw facts for you to be able to answer. Section 14 of the Constitution is quite clear that every person has a right to privacy, which includes, amongst others, two things. One, not to have your property searched, and two, not to have your possessions seized. In this case, you have learners' bags that are searched, and you have the learners' cell phones or mobile devices seized. Isn't that a clear and direct violation of the constitutional provision protecting the right to privacy?
Your Justice, to answer your question, we submit that this is not a justifiable reason for the learners to not being searched, because the school is a public institution and therefore it is someone else's territory, with the school not only focusing on one person's interest but on the other learners as well, Your Justice. If it please the court, I would like to...
In public domain, are you saying if we are in public domain, we do not have the right to privacy? In effect, if I am in public, I don't have the right not to be searched and not to have my property seized.
Your Justice, in a public institution, the right to privacy. Your Justice, in a public institution, your right to privacy can be limited, provided it's for a reasonable and justifiable cause, if that answers your question. With that being said, Your Justice, I'd like to...
can you kindly show how you have limited the right within the ambit of the Constitution, not using sections 4 of the Code of Conduct? Because I mean, in accordance with sections 2 of the Constitution, even section 4 should pass constitutional muster.
Your Justice, to answer your question, according to the South African Schools Act, it is stated that a principal can only search the learners if there is a reasonable and justifiable cause, or maybe when it states that the principal or his or her delegates may randomly search a group of learners for any dangerous object or illegal substance. Well, in this instance, Your Justice, a cell phone is dangerous.
No. I do not consider, 1, the cell phones were not being used. 2, some of them were even off. 3, how do we qualify a cell phone as a dangerous weapon or a dangerous instrument for the health or for the safety of other individuals?
Your Justice, in this case of Mdonolo Combined School, the cell phone is dangerous because looking at the history of the school, the learners used to bring cell phones for unreasonable causes, and with that, they were violating section 4 of the school's code of conduct as they were using the
danger. Where is the danger element? What's the danger it imposes? Is it explosive? Is it gonna spread a virus? What's gonna happen? What's the danger?
The danger in this instance, Your Justice, is the danger to education as it makes learners not to focus on academics, but rather focus on the use of cell phones, which is not for a good reason, if that answers your question, Your Justice.
I think the provisions are very clear that the danger, so the provisions contextualize danger to health and safety. So perhaps would you show me how is it dangerous to the health or the safety of the students or the staff?
If it pleases the court, Your Justice, would you please rephrase your question?
The provisions regarding the searching, for example, when there's reasonable suspicion that somebody might have something that is dangerous, speak directly to danger or have been interpreted to speak directly to danger insofar as it relates to the safety and the health of the teaching staff as well as the students or the staff and the learners. So how, in this case, is a mobile cell phone dangerous to the health or the safety of the staff or the students?
To answer your question, Your Justice, according to section 4, subsection B of the Constitution, which states that everyone has the right to have their environment protected for the benefit of present and future purposes. In this case, Your Justice, when the learners bring cell phones to school, they are not guaranteed that they will have a bright future, as they will be shifting their focus from academics, but rather of disruptive matters, Your Justice, if that answers your question.
You may proceed.
With that being said, Your Justice, I'd like to move on to my second issue, which is the rights to education and why we have limited this right in this case. Your Justices, with the use of the international law, we would like to submit that the NI government services of the United Kingdom states that a child can be suspended from school when 1, they have seriously broken school rule, and in this case, Your Justices, learners purposefully broke the school rule of the prohibition of cell phones.
Sorry, Ms. Mnyaka. There's a difference between international law and foreign comparative law. So what you're telling us now is what the law is in Ireland, And I would want to know what is the value of you giving that to us, because there's a difference between that versus the UNCRC or the African Charter or the ICCPR, which are international instruments. So what are we to make of what Ireland is doing? Because that's a different context. The children are not like the South African children. The context is, so what value must we attach to that?
To answer your question, Your Justice, according to Section 39 of the Bill of Rights, subsection 1A, which states that the use of international law must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. And also subsection C states that the other country may consider foreign law. And in this instance, Your Justices, that is why we decided to use the international law for this case. If it pleases the Court of Justices, I'd like to proceed with why we have limited the learners' rights to basic education. We submit that allowing them to study in school would seriously harm the education of welfare of other learners. And in this case, Your Justices, the applicants were infringing the learners' rights to education as well, because they blocked the entrance of the learners in their strike and protest. With that being said, Your Justices, we would like to submit that a learning environment is not for the benefit of one learner, but for the benefit of all the learners in that particular learning environment. We submit South African Schools Act of number 84 of 1996, Section 8, subsection 2, which states that a code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. Your Justices, we believe that the school's code of conduct is constitutional as it produces a conducive and productive learning environment for the learners. With that being said, Your Justices, we would like to submit the MEC for Education, KZN, and others versus Pillay case, which states that rules are important to education. Not only do they promote an important sense of discipline in children, but they prepare them for the real world, which contains even more strict and serious rules other than those imposed in the school. And Your Justices, we believe that suspension is also there in the outside world. For example, if you are working when you're old, you need to be responsible and follow the rules and procedures, because your suspension can be a life-changing decision towards your work, as you may end up losing your job and not having enough funds to provide for yourself.
True, Counsel. I think I will briefly just contextualize this question here. This court has on numerous occasions, and even our other courts, for example, in Juma Masjid, in Moko versus the acting principal of Umalusi, even in Satao versus Garves, held that when we limit rights, we must ensure that the limitation sufficiently justifies the reason that we are limiting that right for. In this case, you are limiting the right of students to access an education by suspending them. And in Morocco, for example, the court said that suspensions usually lead to a violation of the right to basic education because it places an unreasonable hold on the careers of students because, they may fail the academic year, etc., 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 etc. Juma Masjid tells us best interest of the child all the time must be considered. How do we then reconcile the best interest of the child, as was said in Juma Masjid, the fact that you are placing an unreasonable hold on the careers of the students by suspending them and therefore violating their right to education in terms of Morocco, as well as Sat'au, which says there must be this sufficient relationship that justifies why you are limiting this right in this case. So I see your time is almost running out. You have less than a minute. I just need you to let me know, how have these decisions been effectively considered in deciding to suspend the learners in this case?
Your Justice, to answer your question, we would like to submit the in loco parentis, which means that at the school, teachers are the parents of the learners, as they are under their watch and guidance, Your Justices, if that answers your question. And with that, we submit that the learners in this instance were not acting lawfully as they were against this Section 4 of the Schools Code of Conduct, which is aimed at helping them in their best interest, which is education, in terms of Section 28, subsection 2.
Thank you. We will now hear from your co-counsel. Counsel, we are ready when you are.
Good day, Your Justices. As my co-counsel has stated, I am Lubanga Mlamli, and today I'll be taking 10 minutes of this court's time, basing my case on whether or not the SGB's decision is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. So with that being said, Your Justices, we submit the Regulation of Gatherings Act number 205 of 1993, Section 3, subsection 1, which states that the convener of a gathering shall give notice in writing signed by him of the intended writing. And Your Justices, since in the second and the third gathering done by the applicants in this case required notice, and while the court is aware that the applicants in this case didn't produce the requisite notice, then that gathering or protest must be deemed unconstitutional. And to further drive this, Your Justices, we submit the Mlungwana versus State case, paragraph 16, which states that if a gathering proceeds without a formal notice, then Section 12, subsection 1A of the Gatherings Act provides that it is a criminal offense to convene a gathering without giving the notice as prescribed in the Act. And it is only a convener who is criminally liable for failure to give notice in this case, Your Justices. And we see that since...
However, I'm quite more interested to hear what your response is in respect of the argument that the applicants have made. The applicants have asserted that you did not follow proper procedure in accordance with sections 9 of the South African Schools Act before suspending the learners, because you are required by law to give them a proper and a fair hearing before you suspend them. Now, in your case, when suspending the learners, you did not follow that necessary administrative requirement. Isn't that then an indication that there was an irregularity, which results in, a material irregularity, and therefore this court must set aside the suspension that you have given to the students because you did not follow the proper procedure?
We submit, Your Justices, that if we look at the facts, Ms. Khoza actually, we see that Ms. Khoza actually planned a meeting that specific day the learners were protesting. And we see that since Ms. Khoza said that a way forward must be found if any mistakes are made, then learners should come forward and voice out what they have in question. And we see that since they protested, Your Justices, that led to a confrontation and with the road users, and also they placed bins in front of the school premises, not only preventing teachers entering school premises to teach, and not also blocking learners, also blocking the meeting that was supposed to commence that specific day, Your Justices. If it answers your question, we would like to move on with my argument. We again submit Section 36, subsection 1A of the Constitution, which says that due to the nature of the right and the importance of the limitation of the right, and then we submit that the right to peaceful assembly must be subject to limitation in this case, since it is dealing with children specifically who are often associated with destructive actions. And we see that the applicants in this case didn't fail in producing those destructive actions as we have stated. So, Your Justices, moving on to the importance of the limitation of the rights to peaceful assembly, we submit that, but Your Justices, since we're limiting this right to peaceful assembly, it would not be creating a detriment to the learners, but rather favor their well-being and rather favor the well-being of other learners other than them imposed of that specific limitation, if it pleases the court. Your Justices, we further submit the Satao case, paragraph 53, which states that nothing thus far detracts from the requirement that the right in section 17 must be exercised peacefully. And it is important to emphasize that
Satao counsel, but I think it is quite important that I highlight something here. Why should we be concerned about the strike in this case? Because when we are dealing with the suspension, we should remember that the suspension happened before the protest. And so why should we even consider any other action after the suspension? And so far as I'm concerned, you suspended the students after you found them in possession of the mobile cell phones. And so why should we consider whether or not they were striking and, you know, why? I mean, you suspended them after you found the mobile cell phones. There was an irregularity in that suspension as they were not given the fair chance to be heard before they were suspended. So why must we hear anything on protest?
We submit, Your Justices, that the applicants in this case could have at least exhausted less restrictive means to achieve their purpose, like maybe contacting the prefects of the school or the RCL, or maybe writing the letter to Ms. Koza to show their grievances, other than just to jump the gun and go protest, as it is an implementation of last resort, if it pleases the court.
But I mean, what is the effect of the protest in this case? What is the consequence? Why is it even relevant? You know, you suspended them before they protested. So clearly the protest had no consequence on the suspension. They were already suspended by the time they were protesting. Now I want to know, insofar as the suspension goes, how you followed proper procedure in suspending them. How did you limit their rights in the ambit of the Constitution when suspending them?
We submit to Justices that this instance happened the same day the learners protested in the school, the same day Ms. Koza actually imposed that a meeting should be held to find the way forward, as we see in the case, Your Justices. Moving on, if that answers your question, Your Justice, we submit, and we as the Council of the respondent acknowledge the Gatherings Act itself states it is law that not only aims to make protest possible, but it also ensures that the people exercising their right to protest do not unnecessarily fringe other people's rights, and this law should make protest possible, but also regulate them if it pleases the court. So we see, Your Justices, that since the learners dragged dustbins, placing them in front of the school gate and on public roads, we say that we submit that this led to a confrontation with the road users, not only leading to a confrontation with the road users, but also leading to a confrontation whereby the teachers of the school couldn't enter the school premises to teach, and the learners couldn't enter school premises to learn if it pleases the court. And on a constitutional level, Your Justices, we submit Section 17 of the Bill of Rights in the Constitution, which guarantees that everyone has the right to peacefully and unarmed to assemble, to demonstrate, to picket, and to present petitions. But however, Your Justices, the guarantee is not absolute, and we actually justified our limitation on this right to peaceful assembly by pleading to this court that learners didn't abide with being peaceful during their protest, as they infringed on other people's rights. Not only that, but the dragging of bins into public roads, if it pleases the court. And moving on, submitting at a international level, Article 15, subsection 2 of the United Nations Convention on the Rights of the Child, which states that no restrictions may be placed on the exercise on this right, other more than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety. And we see, Your Justices, that the peaceful part of the protest is very important and very essential to actually protesting. And we submit to this Honorable Court, that since the applicants were in no way peaceful with the protest, then we submit that the protest done by the applicants must be seen as unconstitutional, as they didn't conform with the law. And in conclusion, Your Justices, we as the counsel of the respondent have shown and stated that the school code of conduct is constitutional as it brings about discipline that should be implemented by the school concerning transgressions done by the learners. This promotes self-discipline and encourages good behavior. And with that being said, we therefore pray for the following orders. Number one, we as the counsel of the respondent pray that Section 4 of the school code of conduct be deemed constitutional. Number two, we further pray that the SGB's decision to suspend the applicant in this case to be seen as constitutional. And with that being said, the Justices, I would like to take my leave.
Thank you very much. You were right on time. You had about 2 seconds remaining. We will now hear not arguments, but a reply, a rebuttal from the applicant. Applicant, over to you.
Can I start? Okay. Chief Justice, today's court boils down to 2 points. One on the issue of on the issue of education, and also on the issue of peaceful assembly. So, Your Honor, from the respondent, we hear that they are limiting the right to education just because Section 8A2, or rather, they are limiting the right to privacy just because Section 8A2 of the South African Schools Act allows that. And they say that just because they come and tell us that a cell phone is a dangerous object. And we, Your Honor, we say that this cell phone is actually not a dangerous object because we have to understand this. Your Honor, a cell phone does not harm any person. When these learners are having the cell phones, doesn't harm. Then when they refer to the point of learners using social media, we have to understand that the learners here, in this case, the 6 learners, their cell phones were inside their bags, meaning that the learners were not using these cell phones, which means that the point of learners being disrupted by cell phones does not make any substance in this case. Apart from that, they come and tell us on the issue of the limitation of the right. Here they fail to prove to the House how this right to how they are able to limit the right to education, because they fail to show us how they take into account the point of less restrictive means to achieve the purpose. Your Honor, on the issue of education, they say that they want to take into contact the best interest of all the other learners, Your Honor. But we have to understand that as a school, they need to care for all the learners, and that includes the 6 learners. Even though the applicants, or rather the 6 learners were wrong to come with cell phones, they still had to take better measures to achieve the discipline, not to just suspend the learners just because they want to take into consideration the interest of all the other learners. There are other means that they can be able to teach the learners. There are other means that they can be able to create discipline. On the other hand, taking into account the best interest of the 6 learners and also the other learners in this case. Now, on the right to peaceful assembly, on the limitation of that right, what they came here and proved is that they proved the nature and the importance of the limitation, but they also still once again failed to show us how the SGB follow the proper procedure on the fair hearing point. They failed to show us that, Your Honor. And apart from that, they also failed to show us on how the right on the less restrictive means point, because, Your Honor.
Thank you very, very much. Your time is up.
Oh, my time is up. Thank you, sir.
All right. Thank you to both teams. I will allow my fellow judges to briefly share their comments, and then we will terminate the session. Thank you. We'll start with Justice Oza. I know she has to quickly rush into a meeting. If you could just give us something quickly.
Thank you so much. Yes, well done to all of you for this getting to the quarterfinals. You know, it's been a long week for you guys, and great delivery. But again, in relation to the substance of how you deliver your argument, please again, well, first thing, try and work on the nerves and be calm. And I think Judge Mateus keeps saying that you must remember the conversation. And I think a few of you got a bit nervous to a point where you calm down and try and just deliver. And when we ask questions, remember it's an opportunity for you to clarify and show and engage with the facts. It's really not trying to catch you out. So that's very important for you guys to remember. If you get to the next round, you will have to really work on that and make sure that when you finish your argument, you've covered what you needed to in a way that it's clear to the judges. So thank you so much, and all the best to all those who go to the next round, but also all the best to all of you, because you've done so well. For people who are in high school, you really are doing great. There's some real life advocates who cannot even argue as good as you guys do. So all the best for the future.
Thank you very much, Justice Oza. Over to Justice Sanderson to just give us a brief feedback.
Again, to all the teams, just congratulations. You are all winners already for having made it this far. I echo some of what Judge Oza said. I'm a firm believer of substance over form. So very solid legal arguments. Some of the teams just need to maybe look at the facts a little bit closer, just remember what the accuracy of the facts. But otherwise, in terms of substance, absolutely phenomenal arguments. Just in terms of form, I'm not someone who looks at body language a lot, but I must confess there was a bit of fidgeting, which I know is the nerves. So my only comment I would suggest is just look at your body language a little bit. And when you are not the speaker, just maybe, relax a little bit. There was too much fidgeting with some of the teams, but all in all, well done. As I said to you earlier, substance over form. Well done to all the teams, and we look forward to seeing who comes out on the other side. Thanks, Simon.
Thank you, Justice Sanderson. From me, do not be afraid to be engaged by your judges. As you proceed into the next rounds or the further rounds, you will realize that they do get a little bit much more intensive. And sometimes you have, one of two benches. You have the bench that will ask you questions in between your arguments, and then you have the bench that will ask you questions at the end. Sometimes you have a bench that will not ask you a question at all, but be prepared for either of. Otherwise, best of luck with the sessions that you might have, perhaps if you haven't had any, and if you are proceeding to the semifinals, best of luck as well. That's it from me as well, and I think we have covered all bases. The teams can exit the room, There we go. Right. Hi, Lindy. How are you?
Hi, Simon. I'm very well, thanks. How are you?
I'm great, thank you. It seems I'm not sure how the schedule is running, but I think we are supposed to commence with the semis. Well, we are by schedule supposed to commence with the semis in 40 minutes. That is at 12:30. But that will also depend on whether or not the other judges in the other courtrooms have been able to finish their rounds on time and successfully send in their score sheets to Joyce for finalization. So perhaps you can also just take the next 20 to 40 minutes to finalize your scores and just send them over.
100%. I'll do that quickly. And then I am done, right? You don't need me to do anything else.
I don't think you are sitting in the semis, but let me quickly.
No, I'm not. But so you're fine as long as you've got all your judges. And then sorry about this morning. I didn't want you to wait for me, so I was a bit perplexed
You were actually quite early, which is great because then we are able to finish earlier. We're able to process the marks quite a bit earlier.
That's good.
When there are delays, it becomes a little bit problematic. So thank you for joining right on time.
It's a pleasure, and well done on pulling all this together. I can imagine how tired you must be.
I'm exhausted. I'm exhausted, but we keep on moving.
That's brilliant.
Thank you for joining us. Really
Thanks. Pleasure. See you later. Bye. Bye.
And do give Benjamin a kiss, please.
Oh, you know about my Benjamin. I will. He's just gone to the park. I'll send you a picture.
Thank you.
Thanks, Simon. Take care. Bye.
Thank you very much, applicant team, for those indications. I just quickly need to confirm something here. Justice Sekati, are you with us here?
I am, but I see that we have like an excess of judges. So
No. So this is what will happen. Thank you for being here. I thought you wouldn't be able to make the session. Please preside over this session. I will continue to go to other sessions just in case there is a judge in one of the sessions that's missing, and then I will probably take over in one of those sessions, or I will just monitor the courts. I see you have Justice Adegalu, Kisun, and Shange here with you. So please proceed. You may preside over the session. And yeah, you've been with us, so I don't have to brief you on anything. Enjoy. Thank you.
okay, good afternoon to everyone. I hope that everyone is well, and congratulations to the semi-finalists. I see that both teams have indicated their their names and times. Can we just have both teams just switch on the audio and video so that we can test that out and see if everything is working? So can we start off with the applicants? Could you please switch on your audio and your video just that we can test that out? So just switch it on and say a word or two.
1, 2, 3.
Okay, thank you so much. Could you... Okay, great. And then can we have the respondents do the same? Just, I see your videos already on. Please just say a word or two.
Good afternoon.
Okay, it seems as though your audio and video is working okay as well. So in the interest of time, we're just going to get into it. I have jotted down your time, and I will show you time cards when you're left with 7 minutes, 5 minutes, 1 minute, and when your time has elapsed. So just to show you what those time cards look like, they look like this. They look like that. So just look out for those. And if there aren't any questions or concerns, then I think we can begin. Can we have the first speaker on behalf of the applicant? You may approach the bench.
My justices, may it please the court. I am Boy Wisisiwe, and together with my co-counsel Murubeti Andisa, we appear before this honorable court on behalf of the applicant. As indicated before, I'll be speaking for 12 minutes, and my co-counsel will speak for 6 minutes, and we will reserve 2 minutes for rebuttal. We intend to present to this honorable court 2 submissions with an alternative third submission. Third, my justices, our submissions are as follows. The applicant submits that Section 4 of the School's Code of Conduct is unconstitutional and it violates the applicant's right to privacy and basic education in terms of Section 14 and Section 29 of the Constitution, respectively. Alternatively, we submit that the code should be struck out as it is not a rule of general application and it is applied arbitrarily by the school. Furthermore, the applicants submit that the SGB's decision to suspend the learners is unconstitutional and as it violates the learners' rights to peaceful assembly in terms of Section 17 of the Constitution. My justices, our first submission regarding the unconstitutionality of Section 4 of the School's Code of Conduct in relation with its infringement to the learners' right to privacy and basic education is as follows. Section 4 of the Schools Act states that, and I quote, the use of cell phones, whether on or off, on school premises shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended. Section 4 of the School's Code of Conduct essentially grants the school power to search bags of the learners at school at random and without notice. The effect of this rule is that it infringes upon the learner's right to privacy, a right granted by Section 14 of the Constitution. Section 14 of the Constitution states that, and I quote, everyone has the right to privacy, which includes the right not to have the person or home searched, the property searched, their possessions seized, or the privacy of their communications infringed. My justices, everyone, and we submit that everyone or the search that was conducted on learners was a violation to this right, including the confiscation of their cell phone.
Councillor, I have a question for you. So the right to privacy, is it an absolute right?
My justices, it is not absolute, for it can be limited by Section 36 of the Constitution.
So can you explain to this court how the defendant or the respondent in this case have exceeded the limitation that is allowed by the Constitution?
My justices, may I please defer this question until further of submitting the second submission of the applicant's argument. My justices, privacy is a right that becomes more intense the closer it moves to the intimate personal sphere of the life of human beings. Cell phones have increasingly become more central to human lives. They contain calendars that plan our days, apps that are capable of sharing sensitive information such as banking information, apps that track fertility and other sexual reproductive details of the user. Losing a cell phone, or worse, having it confiscated, takes away the owner's access to all of this. It takes away from the owner's autonomy and arguably their dignity as well, a value granted to everyone by Section 10 of the Constitution. A rule such as this, my justice.
Would you not agree that the school at present has an issue regarding the disruptive or the distracting use of cell phones during class time, as per the facts? Just yes or no?
May you please rephrase your question?
So my question is, the facts indicate that there is a disruptive, that there's numerous disruptions in the school, and that of those disruptions is the use of cell phones. So that is an acknowledged issue in the school. How would you propose that we otherwise address this issue if you do not want phones to be seized or confiscated?
My justices, the best way or the less restrictive means to this case is instead to make fines upon this usage of cell phones or the possession of cell phones, instead of confiscating it, as it infringes upon the learner's rights to privacy in terms of Section 14 of the Constitution.
Council, and who will pay this fine?
My justice, may you please repeat the question?
You said the less restrictive means would be to impose fine. Is that what you said?
On learners found using cell phones in class, yes.
So would the learners have money to pay this fine? Do they have jobs?
My justice, a learner doesn't pay for their own school fees. So instead, they have parents for that who are, in this case, who signed the Section 4 of the School's Code of Conduct, since the consultative process includes parents, learners, and the governing body, as well as other people in the Department of Education.
Okay, thank you.
Yes,
Council.
My justice.
Thank you very much. I'd like to follow up on the question from my learned colleague. Do you think that such an approach would limit the right to privacy in the least way possible, the imposition of a fine, when you consider the number of learners in our country who come from different backgrounds, many of whom are incapable then of being able to pay monetary sums?
My justice, yes, this fine or this alternative, it is the best way due to the fact that most Black parents, to be precise, do not understand the part of paying fines. Therefore, they will make it strict upon their learners or their students or their kids to not bring cell phones to schools because they do not want to pay a fine. Therefore, it will decrease. My justice.
Just a final question on this train of thought. Would this imposition of fine still not require that searches take place? Because how can you impose a fine if you do not know that a cell phone is on one's person? So in effect, so in any event, a search would have to take place. So what do you propose in the alternative of a search? Because that is the issue that you have, that the search violates one's privacy.
My Justice says the Council would apologize for negligence. May I please proceed?
May proceed, Council.
Council, sorry. Are you saying you are negligent in your prosecution before this court? Is that what you just admitted to?
I'm afraid I won't be able to answer that question my Justice just asked.
Okay, I just want to clarify.
So, my Justice, losing a cell phone, or worse, having it confiscated, takes away the owner's access to all of this. It takes away from the owner's autonomy and arguably their dignity as well, a value granted to everyone by Section 10 of the Constitution. A rule such as this one that infringes upon autonomy, dignity, and a right to privacy is surely unconstitutional. My Justice, we would like to remind this court of Section 28, subsection 2 of the Constitution, which informs us a child's best interest is of paramount importance in every matter concerning the child. And Section 29 of the Constitution, which states that everyone has the right to a basic education, including adult basic education. But we saw how when these learners, the applicants, were found in possession of a cell phone, they were immediately suspended for the rest of the year. Not only does this violate Section 29, but it goes against Section 9, subsection 1, paragraph A of the South African Schools Act, which clearly states that, subject to this act and any applicable provincial law, the governing body of a school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. My Justices, the suspension is extreme, as the suspension is extreme and the limitation is unreasonable and not justifiable, for they ought to follow the South African Schools Act and make sure that they are not violating the rights in the Constitution. Secondly, rule of general application. The rights granted in the Bill of Rights are, of course, not absolute. They are limited by Section 36 of the Constitution, otherwise known as the limitation clause. Being that the school seized the cell phones following a rule, and being true that all the rights in the Bill of Rights can be limited, it is also true that the rule that limits the rights should be that of a general application. When the code was first applied in the school ordered a disciplinary hearing to take place following the discovery of a cell phone. Such disciplinary hearing resulted in the suspension of the learner. With the applicant, however, no such hearing was held before they were summarily suspended for the remainder of the school year. Therefore, as this is not really, the question should be asked whether the limitation on the right to privacy by the school code of conduct passes the limitation clause according to the nature of the right, the importance of the purpose of the limitation, nature and extent of the limitation, relation between the limitation and its purpose, and if there are any less restrictive means to achieve the purpose. My Justices.
Counsel, I'm a bit confused there. Is your problem, your contention, is it against the code of conduct or against the application? Because if you are saying that the law, the code of conduct should be of general application, is it the substance itself or the way in which the respondents have administered it? So you said the first time there was there was some sort of disciplinary proceeding, but for these ones, there was none. That looks more like a procedural issue, like not necessarily a substantive issue.
Yes, which then, my Justice, proves that it is not it's not a rule of general application. Okay, and the rights a rule that can limit the rights in the Constitution should be of general application. My Justices, due to time, I'm afraid I won't be able to submit all to this court. So instead, I'll just conclude and ask the court to remember to remind this court of the Western Cape High Court or the case of the Anthony versus governing body that The question should be asked in this regard, whether or not that prohibition is aimed at promoting positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. My Justice, I'll now like to hand over to my co-counsel who will be dealing with the third submission of the applicant's argument.
May it please the court, my name is Morovezi Andisa. As my co-counsel stated, I will be dealing with the third submission, the learners' right to peaceful assembly, which was violated by the school governing body's decision to suspend the learners. My Justices, our final submission is that the school governing body's decision to suspend the learners violates their right in terms of Section 17 of the Constitution, the right to peaceful assembly. Section 17 of the Constitution states, and I quote, "Everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petition." My Justices, ours is a country riddled with a history of inequality, where only a select few were entitled to voice out their concerns and to present petition. My Justices, we are a country with a history of protest action, as this was the only way that the Black population could express themselves legally. My Justices, it was said in the South African Transport and Allied Workers Union and another versus Gavus and another in paragraph 61 that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. This includes groups that do not have
Counsel, I think you may accept that the learned justices and this court has a deep appreciation for the right to protest and expression and the related rights, including the historical foundations and significance for us. We would very much want to encourage you to speak to how you see the number of accusations against the students who took part in the protest and how this relates to the relief you seek in the context of protest and the right to protest. Please. Thank you, Counsel.
May you please rephrase the question?
So, Counsellor, I'm suggesting you can perhaps take it that we've read the papers and we understand then the history of protest and its significance in our democracy, and then perhaps take us to where it is and how it is the argument for the applicant is that this right has been violated.
Okay, my Justice. This includes groups that do not have political or economic power and other vulnerable groups. My Justices, the children are a minority and thus should be treated as so. Protest action is a tool for the minorities to be heard, for the marginalized and the most vulnerable to petition their pleas. It is important to note that in all matters concerning the care, protection, and well-being of a child, the standard that the best interests of a child are of paramount importance must be applied. This is stated in an important... Counsel, just to go back to what my learned colleague said, we are satisfied with the content regarding the right to protest. Please move on to the facts and in applying them. Please refer to the facts and apply the facts to your authority. My Justices, the protest was done under legitimate grounds such as the violation of rights and protocol protected by the Constitution. The learners saw how unfair the situation was as they were not given the right to peace, as they were not given the right to protest, as they were not given the right to a fair hearing. Thus, their only means to express themselves was through protest. My Justices, I would like to remind the court that children are a marginalized group, and their right to peaceful assembly should...
Counsel, just a point of clarity. Is your argument that the process was unfair when the cell phones were allegedly confiscated, or was the process unfair as your colleague puts it, insofar as the suspension was concerned, there seems to be some murkiness. Was the protest because of the confiscation of the cell phones, or was the protest because of the suspension? And then you can possibly then address us on whether the action was within the bounds recognized by the Constitution of the right to protest. Thank you.
My justices, the protest of the learners was done on the legitimate grounds of the unfairness of the situation after their suspension without fair hearing, which goes against Section 8 of the South African Schools Act. My justices, any act that punishes children for exercising their right to peaceful protest, as they will have legitimate grounds based on which their protest is based on, should therefore act unconstitutionally. My justices, we would like to end our argument against the respondent by referring this court to Section 7 of the Constitution, which states that the Bill of Rights is the cornerstone of our democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of freedom, dignity, and equality. The state must respect, protect, as well as promote and fulfill the rights in the Bill of Rights. If there are no further questions, Council, on behalf of the applicant, would like to take its leave.
Thank you, Council. Thank you to the applicants. Can we have the respondent team first speak whenever you're ready? You may begin.
As the court pleases, I will be addressing the issue of how the SGB's decision is not unconstitutional, nor does it violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. My co-counsel, Ms. Nsmcc, will be submitting the issue of Section 4 of the School's Code of Conduct and how it is not unconstitutional, nor does it violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. Section 17 of the Constitution says, everyone has a right to peacefully and armed assemble, demonstrate, picket, and present petition aligns with the Regulations Gatherings Act that talks about the notice of gathering. This means that the convener of a gathering or a demonstration shall give notice in writing signed by them prior to the intended gathering, prior to the gathering, in accordance with the provisions of this section. The applicants or justices did not give notice on any of the 3 protests that happened. In addition to that, they then violated Chapter 1, Section 3 of the Regulations Gatherings Act that speaks about the notice of gathering.
Council, how do you respond to the applicants or the facts before the court? You refer to 3 gatherings. My understanding is perhaps that the first gathering is alleged to have been spontaneous. Was a notice required even in those circumstances? Is that your submission?
No, Your Justice. I'd like to answer that question in a few moments as I continue with my submission.
Thank you. That's in order, Council. You may proceed. Thank you.
In addition to that, they being the applicants also violated the Regulations Gathering Act that speaks about the notice of gathering not later than 7 days before the notice. During the first protest, the police arrived and told the applicants that they were to leave and stop the gathering as it was illegal and that they did not give notice of the gathering. The respondents left and did the exact same thing 2 more times. 2 more times, the justices. The applicants had their protest for 3 consecutive days, and not on any one of the gatherings did they think of letting the respondents know about these gatherings. Yes, Your Justices, we understand that the first protest happened spontaneously. However, we argue that the second and the third protests were not as unique and as spontaneous as the first ones. We argue that no rights were violated as the applicants themselves failed to give notice prior to those two gatherings. And then tell us about the right that they wanted to exercise. Again, Your Justices, we say that no rights have been violated. Article 21 of the United Nations International Covenant on Civil and Political Rights says the right of peaceful assembly shall be recognized. No restrictions of this right no restrictions may be placed on the right except for those that are imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, and the protection of.
Just to interject, Council, I heard you a moment ago saying that no rights were violated. So can you please just indulge me that how is suspending a student for a period of a year not violating their right to basic education because of, if I am not mistaken, the Schools Act says that the maximum period of which a learner may be suspended is not more than 7 days, yet the school's code of conduct says that the maximum period of which a learner will be suspended is a period of 1 year. So can you please just explain that to me, that how is that not violating Section 29 or the right to basic education, if you may say?
Your Justice, Your Justices, the SGB did in no way violate the right to basic education because whenever the suspensions were to be held, the SGB later said that they will be suspended for the maximum period after speaking with the principal. And during that maximum period, the learners would then be getting homework and work during that time to give them more on what they should be doing during that time. They just won't be attending the school, they just won't be on school premises.
Council, but we can assume that in all instances where a learner is suspended, they will receive their school material, and that the Schools Act has considered this when still making their provision on the maximum time being 7 days. So do you not think that suspending a student for over a year, 6 months is not proportionate and is a restriction of the right to basic education?
Just to add on what the anchor judge has said there, do you perhaps think that there are other less restrictive means other than suspending a student for a period of 1 year? And if there are other less restrictive means, would you give any suggestions to the court, please?
And counsel, in the face of your arguments, I would wish for you, in the context of the comments from the learned justices, to answer how it is that the code of conduct is constitutional in your view, insofar as the issue of confiscation of cell phones and privacy is concerned, but also in the context of disciplinary processes that culminate in such an extreme outcome for a student.
Your Justices, before implementing the code of conduct, the principal and the SGB sat down with the parents, the teachers, and the learners as well, talking about or having a conversation about whether they should implement this code of conduct. The learners and the principal, and as well as the others that I've already mentioned, said yes to it, and then they agreed that it was necessary to implement it, as cell phones were a huge problem in the schools. Okay, if it may please the court, I'd like to continue. The applicants did not follow a number of these rules, one being them not given notice for the two protests, Two, being them dragging the large bins into the premises, making it hard for the people around to move, and three, making it difficult for the other learners to enter the school premises during the third protest. The applicants then failed to attend to the responsibilities of the rights that they wanted to exercise. This, your justices, should show how inconsiderate the applicants were of the other learners' rights to a healthy and safe environment, being Section 24 of the Constitution and Section 29 of the Constitution being the right to education. The applicants violated other learners' rights when they made it hard for them to enter the school premises and when they dragged the large bins. And not only did they violate the learners' rights, they also violated the people that moved around the neighborhood when they made it hard for them to pass around that same road when they dragged the large bins into the premises. That disrupting the peace and the safety of the neighborhood. Your justices, before our clients reached their final decision, they had tried a number of times to come to a conclusion with the applicants. Our clients sent a message to all parents of the learners in the school saying that if they felt that mistakes had been made, it should be discussed and a way forward should be found. An urgent meeting was called and was to be held. However, when Eddie, one of the applicants, texted their friend and told them to come bring the posters and protest against this, they made it hard for the people that were supposed to be at the meeting, attend the meeting, as they confronted them and they had led to a confrontation and they blocked the premises to the school. The meeting could not be held. And they took away that one opportunity that could have prevented everything that is happening right now. The one opportunity that could have had the grievances heard, and yet they blocked the entrance to the meeting and to the school, and the meeting could not be held. The SGP's decision did in no way violate the learners' right to peaceful assembly. As our clients, Judge Justice, it seems I have run out of time. I'd just like to ask if I may just give a brief summary or conclude my speech.
Council, I'll give you 30 seconds to conclude and hand over.
Our client's decision was in no way unconstitutional because before making the final decision, our clients did try to reach a conclusion with the applicants due to their protesting. Yet the applicants did not allow them to do so because they blocked the premises to the one meeting that could have prevented everything that is happening. Counsel for the respondent therefore pleads that the Honorable Court rules in favor of the SGB's decision as constitutional and that our clients did in no way violate the applicant's right to peaceful assembly in terms of Section 17 of the Constitution. That being said, I'd like to conclude. Thank you.
Thank you, Council. Can we please hear the second speaker?
May I begin?
Please begin, Council.
If the court pleases, I'd like to begin with my rebuttal. The team respondent told us that they referred to Section 28 of the Constitution, which speaks on having the best interest for the learners, for children in everything that is considered. We tell the court that Section 4 of the Mjondolo Combined Schools Code of Conduct is indeed in the best interest of the learners in the Mjondolo Combined School, as it helps them maintain discipline at the school. It helps the learners have a high quality learning process within the school premises and maintain the 70% pass rate they have managed to achieve now. Secondly, the applicants can...
Also, can you please clarify for this court how suspending the students for over 6 months or 1 year, like my learned colleagues have said, how does it amount to the best interest of the students in this instance?
Your Justice, Section 4 of the Code of Conduct is not only about suspension and confiscation of phones.
It is about the school implementing a way to remove the ill discipline of learners not using cell phones in class, which leads them to be
Council, on what basis did the school suspend the students?
On the basis of them not following the code of conduct, sir, implemented for their best interest.
So how is that different from saying that the section, the code of conduct is not in the best interest of the child, of the students?
Your Justice, we argue that the suspension was to make sure that the learners never bring their phones again to school. And in their suspension, they still get schoolwork, Your Justice. Suspension just does not allow them to enter school premises. In that way, they can still continue to learn at home. Their right to education, therefore, not being blocked because they still get to learn. Everything that is done at school, they get to do at home, Your Justice.
Thank you.
The applicants, the
Council, before you continue, I just want to clarify if this is your submission. Are you submitting that by imposing the suspension and by sort of restricting the suspended learners' rights to some extent, that you are in turn promoting and protecting the other learners' rights to education because they will not be, exposed to all of these distractions? Is that your submission? Or do you have, or could you, if it isn't, could you then please clarify what your submission is in that regard?
Your Justice, we are submitting that by showing the other learners in the Njondolo Combined School that bringing a cell phone to school has its repercussions, we are showing them that they need to not bring their cell phones to school and instead bring their focus to their school books, Your Justice. That is what we're submitting.
Counsel for the applicants cited some authority to this court on which they premise their arguments. Do you have any authority on which you wish to premise your arguments? The judgment of the Western Cape High Court in the matter of Anthony was cited. Do you have any authority, and what is your interpretation of that judgment, if you do wish to address it?
Your Justice, if I may I please continue with my presentation as it responds to your question?
Yes, please continue. Thank you.
We, counsel for the respondent, argue that Section 4 of the Code of Conduct is not unconstitutional. It does not violate the learner's rights to privacy in terms of Section 14 of the Constitution, and does not violate the learner's right to basic education in terms of Section 29 of the Constitution. Your Justices, in terms of Section 4 of the Njondolo Combined Schools of Code of Conduct being unconstitutional, we state that it isn't, as Section 8, subsection 2 of the South African Schools Act states that the code of conduct of any South African school, as referred to in subsection 1 of this act, must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the learning process. Your Justice, this Njondolo Combined School was a school which faced a lot of discipline problems. One of the problems being the use of cell phones during classes instead of listening to the teacher. This is exactly why the SGB, the principal and the learners decided to implement this in the first place. It was implemented to stop the learners from being on social media instead of focusing in class, as it was a big problem that needed intervention. This was only one of the implementations made, but the improvement of the school's pass rate from 53% to above 70% is a clear indication that this was indeed created in the best interest of the learners and in alignment with the laws in the South African Schools Act, and also Section 28 of the Constitution, which speaks on making decisions that are in the best
Counsel,
Yes,
just to interject, can you by somehow link the increase of the school's pass rate to Section 4 of the School's Code of Conduct. Could you please just show me the link between the two, the link in the increase of the school's pass rate and Section 4 of the School's Code of Conduct?
Your Justice, we believe that the low pass rate of the school was created by lack of discipline. Their problems were the use of cell phones during class and late coming. We dealt with the use of cell phones by implementing Section 4 of the Code of Conduct, which did not allow the learners to use cell phones or have cell phones in school premises. As a result of them not being able to bring cell phones, that led to them having to focus in class because they had no social media to distract them. We believe then more focus in class leads to a better learning process. A learning process then means a better pass rate. If your Justice pleases.
Counsel, just to follow up on the question asked by my learned colleague, I'm just wondering, so you said because the Code of Conduct was passed, then the students stopped coming with their cell phone and there was less distraction. But this is why exactly you are before this court. The students are still bringing their cell phones. So I am not convinced that there's a link between the Code of Conduct and the pass rate, because it means in reality, the students are still bringing their cell phone.
Your Justice, if we check clearly in our case, the search was conducted with the whole entire school. And we believe that it is problematic but impressive that only 6 learners in the school brought cell phones that day. That means that the others were managed to follow the rules. This is why we, counsel for the respondent, find it important that we deal with the 6 learners that did not follow proper school protocol, which is in their best interest. If your Justice pleases. Secondly, in terms of the learner's right to privacy being violated, we argue that the school did not violate the learner's right to privacy. It had simply limited their right to privacy. The limitation of the learner's right to privacy is also in accordance with Section 8A, subsection 3, Article 3 of the South African Schools Act, which states that the school may conduct a random search if reasonable evidence of illegal activity taking place is given. Having a phone at Njondolo Combined School is now illegal activity since Section 4 of the Code of Conduct has been implemented. The school had found Sfiso Tele with the phone. We believe
Also,
that
surely there's a difference between illegal activity, which I suppose would refer to drugs or alcohol, or versus activity that is prohibited under the Code of Conduct. So could you maybe indicate why we should apply such a similarly strict approach that we would have otherwise applied to drugs and such to cell phones? Could you answer that question and then give us your prayers because your time is elapsing?
Your Justice, we believe that the South African Schools Act is merely just a guideline on how a school should actually create their code of conduct. Cell phones were a very problematic thing in the Njondolo Combined Schools Code of Conduct, which is why we believe that it is proper for us to view them as a form of illegal things in the school, such as how drugs are problematic in other schools. If your Justice pleases. We, the counsel for the respondent, pray to this honorable court to declare. We, the counsel for the respondent, pray to this honorable court to declare Section 4 of the School's Code of Conduct as constitutional and not in violation of the learner's rights to privacy and education. And we pray to this court to consider it as a section that is in the best interest of the learner's learning process. Thank you.
Thank you, counsel. Thank you to both the applicants and the respondents. Can we have the applicants please give their rebuttal?
My Justices, our video seems to be unable to start. Firstly, my learned friend stated section 3, subsection 1 of the Gathering Acts, which states that, which refers to a notice being needed. But my justices, a notice is needed only when those protesting are more than 15, but we only have 6 learners who protested upon the unfairness of the situation and the suspension with no fair hearing. My justices, the applicant did not violate the other learners' rights as they are protesting.
Counsel, just to interject, you are saying that there are only 6 learners protesting.
The initial...
I don't think that is correct, because according to the set of facts, it says that, and I quote, but now approximately 100 learners convene outside the school gate. So yes, please just answer or clarify that for me. If you made a mistake, then concede that so we can.
My justices were referring to the first protest.
Okay, thank you, counsel.
Secondly, the applicant did not violate the other learners' rights as their protest was based on legitimate grounds, the unfairness of the situation as they were not given the opportunity to a fair hearing. Thirdly,
Counsel, I know you are out of time, but I would just want to quickly ask. So you said you were referring to the first protest. What about the 2 other protests? Are they irrelevant before this court?
Yes, please also clarify that for me. Thank you.
counsel submits negligence. Thirdly, there is no direct link between the lack of privacy and improved marks. Fourthly, counsel for the respondent stated that the respondent's decisions are in the best interest of the children. But my justices, taking into factor that the school's procedures go against protocol, which are proved by the following: the usage of corporal punishment in the school, although it is legal in South Africa, the learners did not receive a fair hearing.
Thank you to the applicants and thank you to the respondents. I think in the interest of time, we won't give much feedback, but just from my end, well done again to both teams. We hope that you make it all the way. If there are any quick remarks, quick feedback from the judges, I think you can give it now. I'm just not sure how we are on time. But from my end, well done. And wish you all the best with the round to come.
Thank you so much, Justice Kati. If I may also quickly give some comments and feedback to say congratulations to both counsel. You were all excellent, I thought, and far more courageous in the face of tough questioning. I'm trusting that going forward in your career, as scholars and as the youth in our country, you will continue to engage with basic rights in a clear way and to appreciate, as you've done before us, the need to carefully interrogate and understand the rights and to be able to defend them, but also to be able to scrutinize laws and practice that may sometimes be offensive to rights. So thank you very, very much for your efforts. I thought both teams did really well. Thank you so much.
From my side, I'll just quickly say, the two justices have said, well done to both teams. I think you guys did fantastic. I would just give one comment. I think to the extent possible, when the justices ask you questions, going forward, hopefully you progress to the final, don't deflect your questions. Don't say, I will answer that in the course of my presentation, because it's supposed to be a conversation with the judges. So if you somehow have the answer somewhere, just quickly look through and try to answer the question to the extent possible. I think that's the only feedback that I would like to give you guys. Otherwise, well done.
From my side, I would also just like to congratulate both council and yes, say that I'm really proud to hear that high school kids can argue about law to such a great extent. And yes, I wish you guys luck and yes, the best of luck in the tournament ahead. Thank you.
If there aren't any questions or concerns from the team, then I ask that you all please leave the meeting so that the judges can move on to the next session. Thank you so much.
Hello, colleagues. I'm not sure what happens now. Do we go into the next session or what
I think
happens?
that if ever your next session is in this court, then you are supposed to remain behind. But if ever your next session is in another court, then you are supposed to leave this courtroom and then go join that other court.
Thank you so much. Thank you. I'm not sure. And how do we then, and who do we send our scoring to for this round or this session?
I think you are supposed to email Joyce and then CC Phillips and Simon.
Okay, thank you so much. That's helpful. Thank you.
Yes. Good afternoon, everyone. Yes, congratulations for making it thus far to the competition. So I would like to, before we commence, I would like to ask the team applicant, the first and second speaker, to write their names there in the chat box, please. Okay, may I also ask the second speaker to write his or her name there in the check box. Okay, thank you very much, team applicant. Okay, so team respondent, please, the first speaker and the second speaker, write your name there in the chat box for us, please. Okay, thank you very much. Okay, so yes, my name is Judge Kalipashange, and I'll be the anchor judge for this session. And I think I'm with my colleague, Justice Kisoon, and I'll just afford them the opportunity to introduce themselves, and then we will begin with the team applicant. Thank you. Justice Kisoon, you may introduce yourself.
Thank you, Justice Shange. Thank you so much. Welcome, Council. Looking forward. Thank you.
Okay, thank you very much, Justice Kisoon. Okay, so I'm sure that now the teams are familiar with the rules since they've made it thus far to the stage of the competition. So yes, you know that each team is allowed to speak for a maximum of 20 minutes, and one speaker may not speak for more than 10 minutes each. So, and the applicant, they have a right to reserve some time for rebuttals, and I can see there in the chat box that they've just sent a text that they reserve 2 minutes for rebuttals. So, team applicant, you may commence with your arguments, and I will be I'll just keep reminding you how much time you have left as the section progresses. Thank you. Team applicant, thank you.
As it may please the court, my name is Siphola Zimtali. I appear as the first counsel for the applicants. I appear together with my co-counsel, Nonduduzo Tangazela. There are two issues that lie before this court. The first being the unconstitutionality of Section 4 of the Schools Code of Conduct, which is found to be violating our clients' right to privacy and basic education in accordance with Section 14 and 29 of the Constitution. The second issue is that the SGP's decision is unconstitutional and violates our clients' right to peaceful assembly in accordance to Section 17 of the Constitution. I, as the first counsel, I will be dealing with the first issue and be arguing for 9 minutes. My co-counsel shall proceed and attend to the second issue. She shall also argue for 9 minutes, and we will reserve 2 minutes for rebuttal. As a starting point, counsel for the applicants request to bring the two following points before the court. The first point being that the Constitution of the Republic of South Africa is the supreme law of the country as it is stated in Section 2 of the Constitution. This means that any law or rule or that is found to be violating the Constitution must be amended to remove the unconstitutional parts or declared invalid. For us to ensure that decisions made by our courts are respected, I would like to refer you to the matter between MEC for Education versus Pillay, the case of 2007, number 51, paragraph 6, where Sonali Pillay was the young South Indian lady that used to wear a gold nostad in respect to her religion. Now, I am aware that religion and education are distinguishable. However, the principle still stands. The principle, which is the principle of case precedence, which ensures that justice and fairness is ensured in our courts and random decisions are not taken by our courts. Your Justices, the first issue that I'll be arguing upon is the irrationality of the school's code of conduct. It might have been promulgated with the participation of the SGP, the learners, the educators, and parents. However, its implementation is too broad. Hence, now it is found violating our clients' rights to privacy and basic education. Section 14 of the Constitution states that everyone has the right to privacy, which includes the right not to have A, their person or home searched, B, their property searched, C, their possession seized, or D, the privacy of their communications infringed. Your Justices, I request the leave of this court to refer you to the matter between Head of Department of Education versus Welcome High School, the case of 2014, number 228, at paragraph 58, where it was stated that that state functionaries, including schools, may do what the law permits them to do. However, they may not go beyond what is required by the law. The court further stated that the principal, as the head of the school, has prerogative to ignore the policy of the governing body if it is unconstitutional. It is with respect that I submit that the whole world is moving towards fourth industrial revolution. The school must create mechanisms to integrate the use of cell phones for the purpose of teaching and learning. I humbly submit that learners should be encouraged to bring their cell phones so that they can be able to record lessons in class and for them to be able to download material that might assist them get a better understanding of their schoolwork. However, this does not mean that discipline should not be enforced. Discipline can be enforced by instructing these learners to only use their cell phones for the purpose of teaching and learning, and for them to ensure that their cell phones are kept on silence at all times. Your Justices, I humbly submit that Section A of South African Schools Act provides for random search and seizure. However, it clearly states that a principal or his or her delegate may at random search a group of learners or the property of a group of learners for any dangerous object or illegal drug, but not to get it like a cell phone. Therefore, it is an unreasonable suspicion that was established by the principal's order of Mthondo Combined School. It has invaded our clients' privacy and has infringed their constitutional rights. Your Justices, I would like to outline the guidelines for search and seizure practices in South African schools, where it is stated that searches are conducted after considering all relevant factors, such as A, the best interest of the learner in question, B, the safety and health of the learner in question, and C, reasonable evidence of illegal activities.
Counsel, may I ask you, are you suggesting that the right to privacy may never be limited? Or must this court understand you to mean that the right to privacy can only be limited on the grounds that you have mentioned, for instance, in relation to searching for a dangerous weapon? Is that your argument to this court?
Yes, Your Justice.
I see. Okay. Would there be any other justification to limit the right to privacy?
Thank you for your question, Your Justice. Yes, the right to privacy might be limited if less restrictive means are considered, of which in this case, they were not considered by the respondent.
Thank you, Counsel.
Counsel, just to interject, you are saying that the right may be limited if ever there are less restrictive means that are considered, and those less restrictive means were not considered in this case. What would those less restrictive means be?
Thank you for your question, Your Justice. However, I would like to submit that to justices that by confiscating our clients' cell phones, the school had achieved its purpose of discipline. However, by going far as to suspend them, that too for the period longer than 7 days, which they were suspended for the rest of the year. They could have suggested that after they have confiscated the learner's cell phone, they be taken to counseling and parents' involvement would have been suggested. However, the respondents did not consider such because they did carry on by confiscating their cell phones and that too suspending them from the rest of the year.
Okay, counsel. So I just want clarity on this. Do you only have a problem with the procedure in which Section 4 of the School's Code of Conduct was enforced, or you also have a problem with the substance, as in the substance and the content of Section 4 of the School's Code of Conduct? Please just clarify that for me. And by that, I mean, by the procedure, I mean, do you mean that you have a problem with the suspension period, the sanction, or you have a problem with how Section 4 was enforced?
Thank you for your question, Your Justice. However, I submit that the implementation of Section 4 of the School's Code of Conduct is problematic because it goes against Section 9, subsection 2 of the South African Schools Act, which states that the sanction imposed on a learner must not be punitive, of which in this case it is, and it must be only aimed at rehabilitating the learners.
So, counsel, just following on my learned colleague's question, is to say, are you then going to abandon your argument that Article 4 of the code is too broad because it's including items or powers that are not catered for in the Schools Act specifically?
Thank you for your question, Your Justice. The answer to your question is both.
Thank you very much. Thank you.
Okay, counsel, just bear in mind that you now have 90 seconds to wrap up your argument, and then the second speaker may take over.
Thank you for your question, Your Justice. I would like to submit that education is central for every child's development, as it is the key to a better life. It has been populated that education is a bridge from misery to hope. If I may refer you to the case of Federation of Governing Bodies for South African schools versus member of the Executive Council, the case of 2016, number 29, at paragraph 44, it was stated that public schools are not refined spaces only for the bright, well-mannered, and financial well-hid learners. They must not only advance the parochial interest of immediate learners. So, Justice, I humbly submit that our clients should not be suspended from school for the rest of the year just because of the cell phones that they brought to school. Because a public school must offer learners universal access to education. I've come to the conclusion of my arguments. If there are no further questions to be asked, I request the leave of this court to hand over to my legal counsel as she will further elaborate.
Okay, yes, thank you, counsel. Your time is up. Second speaker.
As it may please the court, justices, for the sake of the record, my name is Nontutuzo Tangazela. I appear as the second counsel for the applicant in this matter. Since my learned co-counsel has dealt with the first issue, I will proceed on settling the second issue, that the SGP's decision is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. Justices, it is accurate to articulate that even the balancing test does not prove it right. Education has more value than cell phones being carried to a school that doesn't permit them. Therefore, I can confidently say that the school's code of conduct is unreasonable and unjustifiable according to all the evaluation done at Section 36 of the Constitution. Any law that is not in line with the Constitution is invalid. Justices, if I may refer you to the hypothetical case 2021 in paragraph 2, it is stated that the learners are punished even for small transgression and corporal punishment is enforced. Section 10, subsection 1 of South African School Act number 84 of 1996 clearly provides that no person may administer corporal punishment against a learner at a school. As the Constitutional Court stated in the matter between Christian education...
Counsel, I don't think there's a dispute on those facts. We understood that corporal punishment has been withdrawn. Perhaps this court can direct you to address the peaceful assemblies argument that you wish to present to us.
Thank you, Justice. With respect, I humbly submit that counsel for respondent must review South African School Act number 84 of 1996, section 9, suspension and expulsion from public school. It states in subsection 1, a governing body may on reasonable ground and as a precautionary measure suspend a learner who is suspected of serious misconduct from attending school, but may only enforce such suspension after a learner has been granted a reasonable opportunity to make representations to it in relation to such suspension. It is my submission, Justices. In the state of fact, paragraph 6, it is stated that the 6 learners are immediately suspended. Therefore, the school acted unconstitutional and irrational of it to suspend our clients for the rest of the year as they violated their right to adhere to disciplinary proceeding supported by subsection 1A, inserted by section 2A of Act number 24 of 2005. It states that a governing body must conduct disciplinary proceedings in the manner contemplated in section 8 against a learner within 7 school days.
Just to interject, counsel, I just have perhaps a direct question for you. Was the assembly or the demonstration by your client peaceful?
Thank you, Justice. The answer to your question is yes, as it is provided in the set of facts, paragraph 9, that the group was formed spontaneously. Also, if I may refer you to the matter between Mlungwana versus the state, case number 32/19 on the Constitutional Court 2019. It was stated by the Constitutional Court in paragraph 16 that it is open to a convener to invoke a defense that the protest took place spontaneously.
So sorry, counsel. Are you submitting to this court that just because the protest was spontaneous, then it means it was peaceful?
Thank you, Justice. According to the guideline of freedom of assembly in Africa, it is stated in paragraph 17 that the protest should be deemed peaceful if the organizers are expressing peaceful intention and lawful intention, Your Justice.
Okay, thank you, counsel.
Okay, so counsel, if I'm not mistaken, according to the set of facts, there was actually a fire which broke out later that evening. So, what do you make of that, counsel?
Thank you, Justice. If I may refer you to the hypothetical case, it is stated that no culprits were identified. Justice, if I may proceed. The school policy is unconstitutional. Section 17 of the Constitution states that everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petition. Section 39, subsection 1B of the Constitution states that When interpreting the Bill of Rights, a court must consider international law. It states the Universal Nations Convention on the Child's Rights. States parties recognize the child's right to freedom of assembly as well as to freedom of expression in terms of Section 18 of the Constitution. If I may refer you in the matter between South African Transport and Allied Workers Union on 2013, also known as the Satau case, the Constitutional Court in paragraph 52 stated that everyone has the right to go out, picket, demonstrate, and present petition. And also in the very same case in paragraph 62, it is stated that spontaneous and organized demonstration or protest are important way in which people can express themselves with justice. Therefore, I have submitted that protesting serves as an important instrument for democracy and for people who are oppressed.
Counsel.
Okay, Counsel. Justice. Yes. You may go ahead and ask your questions. I'll ask after.
Yeah. All right. Thank you, Justice. Counsel. Does Section 17 of the Constitution protect a protest of this nature, where dustbins were put on the road and where the movement of people and vehicles was disrupted? Does the Constitution protect a protest of that nature?
Thank you, Justice, for the question. Yes, it is provided in the set of facts that, again, in that matter, the no culprits were identified as it wasn't stated that the 6 learners were the ones who put the dustbin.
Thank you, Counsel. Thank you.
Okay, Counsel. So, Counsel, my question to you is, there was a school's code of conduct which was enacted, and then the students contravened the school's code of conduct, and then they were subsequently suspended for that. So my question to you is there no other alternative way in which your clients, being the suspended students, is there no other alternative way in which they could have resolved this matter other than protesting and picketing? And if there is other alternative ways, please suggest, if there is, of course.
Thank you, Justice. Yes, there is. Paraphrasing Section 36, it states that there must be a general application of the law. It must be within the spirit of the Constitution of freedom, equality, and dignity. There could have been a less alternative way to limit the apply of rights by saying to the learners, don't use your cell phone during teaching hours, but banning them altogether, whether on or off, cannot be sustained within our Constitution. Arguments to that effect, Section 36, subsection 1A.
Just note that you have 90 seconds to wrap up your argument, and then you guys will have 2 minutes left for rebuttals, and then the respondent can start. So you have 90 seconds starting from now.
I therefore humbly like to draw the court's attention in the matter between Antonio versus governing body of Settlers High at paragraph 17 in the case of 2002, as the Constitutional Court stated that a question should be asked whether the prohibition is aimed at promoting positive discipline or not, while we know that these learners are minors, and Section 28 subsection 2 clearly states that a child's best interests are of paramount importance. Justices, it is our submission that if this court would let this unlawful school decision, that would mean more than us will suffer what the 6 learners are already suffering, which is their infringement of the constitutional right, which are violated by the respondent. And also, if the school is still refusing our client's simple right to privacy, peaceful assembly, and education, that will be aimed at freeing the learner's potential to a brighter future, as the preamble emphasizes. Counsel for the applicant submits that it has made solid arguments in favor of these learners and prays to this court to find in its favor and upholds this with cause.
Okay, thank you very much.
Justice Shange, may I ask one quick question, please?
Yes, you may.
Thank you, Justice. Counsel, I hear your prayers for relief regarding unconstitutionality, premised or based on violations of privacy and violations of the right to assembly. But if the court grants the relief you seek, what will it do for your clients at all? Can I ask, why have you not asked that your client be readmitted to school as part of the relief you seek?
Thank you, Justice, for the question. In my prayers, I did mention that the counsel for applicant has made solid arguments in favor of the 6 learners, meaning if the court would grant us this appeal, that would mean that these 6 learners would not be suspended and they will be brought back to school. As Section 29 of the Constitution states that everyone has the right to education, Justice.
Thank you so much, counsel. Thank you. Very good. Thank you.
Okay, thank you very much, counsel, for the applicant. First, counsel for the respondent.
That's me, Justice. May I begin?
Yes, you may.
As it is the court, I am Zina Rooms here with my co-counsel, Ms. Cindy Silimankai, and we will be representing the respondent. I will be speaking first for 10 minutes to address issue 1 and 2, which is the alleged violation of sections 14 and 29 of the Constitution, based on section 4, which is the newly added section in the School Code of Conduct. My co-counsel will be speaking for another 10 minutes to address section 17 of the Constitution and how the school governing body's decision does not violate the right, and to conclude. The question before the court is whether Untitled Combined School violated the learner's right to privacy and basic education in terms of section 14 and 29 of the Constitution. The second question is whether the school governing body's decision to suspend the learners is unconstitutional and violates the rights to peaceful assembly in terms of section 17 of the Constitution. In response to these questions, we, as counsel for the respondent, will prove why none of these decisions are unconstitutional. If it pleases the court, I will now continue to address the first 3 issues. Turning to the first issue, which is whether section 4 of the School Code of Conduct is unconstitutional. Untitled Combined School added this new rule to prohibit the use of cell phones on school premises. Any learner found with one will have it confiscated. The respondent disagrees with the applicant's charge that the Code of Conduct is unconstitutional. It is a well-known fact that learners all around the world use every opportunity to be on their cell phones. Thus, they are constantly on social media during lessons, making it difficult for the educator to teach. Section 8.2 of the South African Schools Act states that a code of conduct should be aimed at establishing a disciplined school environment, and we agree that the rule put in place aimed to create a focused classroom environment and was thus successful. Cognizant of Section 36 of the Constitution, we argue that for the learners to receive the deserving education, that the Code of Conduct must reject this harsh punishment of suspension, because the only way the school could have the learners follow this rule is for the punishment to be consequent. It is clear that the respondents were only working in the best interest of the learners. They were being disobedient, and these measures had to be enforced.
Counsel, just to interject. So you are saying that the school's code of conduct, or rather section 4 of the school's code of conduct, is in the learner's best interest. Do you agree on that? Is that what you are saying?
Yes, Justice.
So the punishment, or rather the sanction imposed by section 4 of the school's code of conduct, is that a learner who contravenes such a provision will be suspended for a period of close to 1 year. And so please just indulge me. How is that not a violation of the learner's right to basic education when they have been suspended for a period of close to 1 year?
Justice, in the facts, it does not state for how long the learners are suspended, so we are unsure of what you're stating right now,
Justice. Please just rephrase that. I couldn't hear you properly.
Justice, nowhere in the facts does it say that the learners were suspended for 1 year. It just says they were suspended for the rest of the year. We don't know how long it is for. It could be for more than 7 days, or it could be just 7 days, Justice. We are not sure of that.
Okay, thank you.
Okay. The applicants were being disobedient, and these measures had to be enforced to ensure that no one's futures would be negatively affected. We hereby submit that Section 4 of the School Code of Conduct is not unconstitutional. Justices, if there are no further questions on the first submission, I will now proceed to address the second issue, which is the supposed violation of Section 14 of the Constitution. Section 14 of the Constitution states that everyone has the right to privacy. A learner dropped his cell phone in class and it was confiscated. He had a disciplinary hearing which resulted in his suspension. Ms. Kosa realized that the learners might not have been following the rule and ordered a search of the bags. Our honorable friends argue that this is an infringement of the right to privacy, but we argue that this was justified. Ms. Kosa had a reasonable suspicion and was allowed to search any learner. 6 learners brought their cell phones and were suspended. The same could be said had it been an illegal substance or weapons as these are forbidden items.
Counsel, you are saying that Ms. Kosa had the right to search any students on the school's premises. Which law gives Ms. Kosa such powers?
Justice, I'm not saying that she has the right to search any learner, but I'm saying she had a reasonable suspicion because one learner already wasn't following the rule.
Okay, thank you.
The same could be said had it been an illegal substance or weapon, as these are forbidden items such as cell phones. Therefore, the respondent did not violate the learner's right to privacy, and it is clear that the applicants were disobeying Section 4 of the Code of Conduct. Our honorable friends might also argue that the privacy of these communications were violated, thereby degrading his human dignity. We submit that this is not true, as the Criminal Procedure Act allows any policeman to search any person without a search warrant. They, of course, have to have a reasonable suspicion, and as indicated in the first
Counsel, but Ms. Kosa is not a policeman. I think that we can agree on that.
Yes, Justice.
So then, why is it that this section of the Criminal Procedure Act is applicable? So how is it applicable when Ms. Kosa is not a policeman?
Your Justice, thank you for your question, but I am talking about the part where Aries communications were searched, his phone.
Okay, thank you.
The police, of course, have to have a reasonable suspicion, and as indicated in the first protest, the police could have been suspicious that he was involved this time. Therefore, his cell phone was searched, and his taxi in Bali and crystal was found. It is clear that his right. May
I ask?
Yes,
may I ask your view and position? Is it then the position of your client that a police type environment should prevail within schools?
No, yes, Justice, but I'm just bringing this information forward as it aids in my argument due to the suspension of the learners.
Thank you. Counsel, you may proceed.
Just before you proceed, Counsel, please just, I just want to ask that, are there any other less restrictive means which we could use to punish the students who contravene Section 4 of the School's Code of Conduct, other than suspending them for the rest of the year?
Yes, Justice, we as counsel to the respondent agree that less restrictive means could have been used, and I, of course, will consult my client about that. But the learners are at an appropriate age to understand.
Okay. So, Counsel, what would those less restrictive means be?
Justice, I would say calling their parents and having them come into the school to address the issue of the learners breaking the school rules.
Okay, thank you very much. Please note that you have 90 seconds left on your time, on your 10 minutes.
Justice, I will hand over to my co-counsel to address the rest of the issues then, if that's fine with you.
Okay, thank you very much.
Thank
First
you.
speaker for the respondent. Second speaker.
As it pleases the court, I'm Nsmcc and I will continue to address the third submission. Once again, a protest of which no notice was given was held with approximately 100 learners, contravening Section 3.2 of the Regulation of the Gatherings Act. These learners had posters degrading Ms. Khoza's name, violating Section 10 of the Constitution, her human dignity. The learners were also we can then plead that they were the ones violating Section 10 of Section 29 of the Constitution. A fire was started in the administration office, the administration building, and Tato, Precious, and Apio were arrested. As they were the ones.
Sorry, counsel.
Yes, Justice.
Counsel, can you explain to this court how the protesting learners violated Section 3 of the Regulations of Gatherings Act? That was your opening statement.
And yes, Justice, no notice was given.
And is that a violation?
Yes, counsel. Just in addition to what my learned colleague said, the applicant said that the protest was spontaneous. So then, how was Section 3 of the Gatherings Act violated if the protest was spontaneous?
Yes, Your Justice, I understand that point. The first protest could have been spontaneous, but the ones that followed after that were not spontaneous as they were planned. And according to the facts and the messages found on Eddie's phone, they said that they were going to make posters and meet at the gates to have a protest. So those ones were planned; they were not spontaneous.
I can hear that. The applicant also said that in relation to the fire which broke out, the applicant also said that there were no culprits which were identified. So how are you actually, well, what is the relevance of you telling us that there was actually a fire which broke out later that evening?
Due to the circumstantial evidence, Your Justice, which is the messages found on Eddie's phone.
Okay, thank you, counsel.
Thank you, Your Justice.
Sorry, counsel. Okay. No, it's fine. You can I ask my question? Is there anyone?
Yes, please go ahead, Justice.
Yes. Just counsel, I don't. You haven't answered me on my question. I asked, can you explain to this court how the protesting learners violated Section 3? And in your answer, counsel, just also try and incorporate and convince this court if you are aware of the Mlungwana judgment. Thank you, counsel.
Justice. Thank you, Justice. I'm sorry, Justice. I'm not familiar with the case that you just stated now.
Oh, you're not familiar with the Mlungwana judgment?
No.
Oh, okay. Okay, no. Thanks, counsel. Thank you.
Thank you, Justice. These learners held an illegal gathering because they felt that their suspension was unfair. So we can assume with intent that one of them set the administration building on fire. This is the only reasonable explanation based on the circumstantial evidence, Your Justice. If there are no further questions on this submission, I will continue to address the final submission. The 6 learners say that the school governing body's decision was unconstitutional as they were only exercising their right to peaceful assembly.
Sorry, Justices.
Justices, they were only exercising their right to peaceful assembly. But according to the United Nations Convention on the Rights of the Child, Article 15, subsection 2, it states, no restrictions may be placed on the exercise of these rights other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety or public order, which is what it was trying to achieve, the protection of public health or morals or the protection of the rights and freedom of others. These learners do not only go against Section 3 of the Regulations of the Gatherings Act, they went against the law that says a protest has to be peaceful and no violence is to be used. Paragraph 53 of the Harvard's case states that when the person who has the right to this peaceful assembly has no intention of acting peacefully, that they lose their constitutional protection. And at the protest that they arranged, things would have gone terribly wrong when the burn was set alight. Therefore, the school governing body's decision to suspend them is not unconstitutional, as their right to peaceful assembly in terms of Section 17 of the Constitution did no longer protect them, as they did not act or protest in accordance with this right. Our learned colleagues also stated that our learned colleagues could have used a better alternative other than protesting, which is going home and informing their parents that they have been suspended. Then their parents will come to school and speak to the principal on their behalf instead of protesting. It is justifiable that each of the learners who are arrested and detained at Section 12 and detained at Section 12(1)(a) of the Gatherings Act states that any person who convenes a planned gathering in respect of which no notice was given shall be guilty of an offence and shall be held criminally liable, and in case of a contravention referred to in paragraphs A to J, a fine may be issued.
I'm sorry, Counsel.
Yes, Your Justice.
That particular section, Section 12(1)(a) of the Regulations of Gatherings Act, that section was found to be unconstitutional by them in the Mlungwana judgment, the judgment that I asked if you know about it. That constitutional court case actually found that that section is unconstitutional. So you can't rely on that section anymore. It doesn't exist. It is not in line with our constitution. That's what the judgment says, Counsel.
Thank you, Your Justices, for informing me. I was not aware. I will be well prepared next time to understand. Thank you very much.
Counsel, may I ask?
Yes, Your Justice.
Let's assume that the learners had actually followed the suggestion you propose now on your papers, that they ought to have gone home, spoken to their parents, and then allowed the parents to intervene on their behalf. What about then the rights of the other students who felt equally aggrieved by conditions at the school? What about their rights to express themselves? These are the learners who joined that activity over and above the 6 who had been suspended.
Absolutely, Your Justices. But now this happened in the beginning of this entire case. So if the learners had actually gone home to inform their parents, the other protests, the other learners will not even be part of this case. If that answers your question, Your Justice.
Thank you, Counsel. Thank you.
Thank you, Your Justice. If there are no further questions, I would now like to conclude our arguments. In summation of our arguments, counsel for the respondent has established that the respondent did not violate the applicant's rights to basic education, privacy, and peaceful assembly in terms of Section 14, 29, and 17 of the Constitution. Counsel for the respondent respectfully requests this Honorable Court to please declare the High Court's decision to be correct in ruling in the favor of the full governing body, as the respondent has violated no rights. Thank you, Justice.
Okay, thank you very much, Counsel. You finished before time, so you still have 2 minutes left. But now we will actually ask counsel for the applicant. You have 2 minutes to rebut.
As the court pleases, in respect of the submissions made by the respondents, Your Justices, may I please refer you to the matter between Head of Departments, Department of Education, Free State Province versus Volcom High School, the case of 2014, number 228, at paragraph 46, where the Constitutional Court stated that as a precautionary measure, a governing body may suspend a learner for up to 7 days, pending his or her disciplinary hearing, or such long a time as an HOD authorizes. However, it is my submission that these learners were not suspended were suspended a period longer than 7 days, and they're not given a chance to undergo a disciplinary hearing. The governing body may, in the event of the learner having committed serious misconduct, impose a disciplinary sanction for up to 7 days of suspension. Only an HOD decides to expel or suspend a learner, even for a longer period of 7 days. Your Justices, once again, may I please refer you to the Welcome case, now in paragraph 82, where the court stated that the Schools Act may not empower a governing body to expel or suspend a learner for a lengthy period of time. I would like to bring it to the court's attention that Section 28, subsection 2, states that a child's best interests are of paramount importance in every matter concerning the child. In the set of facts, the second page, it is provided that these learners are between the ages of 14 and 17. They are still minors, hence they still need guidance and protection of the law. Your Justices, if the court pleases, may I please refer you to the South African Schools Act, Section 8A, which states that a school a principal or the principal.
You have 30 seconds to wrap up. You have 30 seconds remaining.
Thank you, Your Justice. As a counsel for the applicants, we would like to bring before the courts that the SGP's decision is unconstitutional and it did violate our client's right to peaceful assembly, and the Section 4 of the Schools Code of Conduct is unconstitutional and violates our client's right to privacy and basic education in accordance to Section 14 and Section 29 of the Constitution.
Councillor Mshali, may I ask, do you have any proposals around costs in this matter? Will you be claiming costs in this matter if you are successful?
Thank you for your question, Your Justice. According to the civil principle, the winning party should claim costs in order for them to pay for their lawyers.
Thank you.
Thank you, Justice.
Okay, thank you very much, counsel for the applicant. Counsel for respondent, you have 2 minutes if you want to rebut.
Justice, we do want to make a few points, please.
Okay, you have 2 minutes starting from now.
Yes, Justice. Your Justices, our fellow learned colleague states that we do not offer the learners a hearing, but knowing the fact does it state whether a hearing did happen or not. So we can't be sure of that with certainty. The second point is they say the learners are suspended for the maximum period. Still, we don't know the maximum period for how long it is, so they cannot be sure it is more than 7 days. That's all, Your Justices.
Okay, thank you very much to everyone. Your time is up now. I will just give my fellow colleagues an opportunity to give you any feedback which they may have. So please just listen attentively for future purposes. Thank you.
I can go first if nobody has a comment. I think all the counsel they argue well, and they responded satisfactorily to the questions. I just have a specific comment, I think, to the second speaker in the from the respondents. It's important that when there's a key issue that you are addressing, I think you are addressing on the right to peaceful assembly. I think it is important that you become acquainted with, the laws, and particularly the recent judgments that speak to the constitutional right to protest. You can't speak about the constitutional right to protest and miss the Mlungwana judgment. It is it's a benchmark case speaking specifically to the failure to give notice and the criminalization thereof. So I think you should have really went through that case and understood what it meant. I think it would have strengthened your argument. But nevertheless, you argue very well and you respond satisfactorily to the questions. And I think that goes to the rest of the council. I think our legal fraternity is in safe hands. So good luck, ladies.
Thank you very much. Thank you. A few comments from me. First, to say congratulations. What a formidable pair of teams you make. You really make us feel extremely proud, and you've done amazingly well. I want to support some of the feedback shared by my colleague just now, is that usually when you are faced or put in a situation where you cannot attest to the facts, it's wise to indicate that you would need to take instructions on that, but also then tactically better not to introduce reasoning or arguments that is reliant on untested facts if it's not clear, so to be wary of that. And then, for instance, where there is, as my colleague was saying, where there's a landmark judgment or authority, it's very recent. This is April, I think. It's quite recent, and it changes the entire landscape. It is important to just have, basic regard to it. But then if you don't, it's helpful to stick to the constitutional principles, because those are not going to change. So, to shift your argument in favor of that which you do know, and then also perhaps to propose more strongly what it is that could have been done differently, with less violation. And the same applies to the respondents. In general, I was really impressed and tremendously proud to have the privilege of hearing both of the teams. Well done, council, for respondent and for applicant. Very well done. Thank you so much.
I must say that I also share the same sentiments as my Leonard colleague. Yes, I would like to congratulate both teams. I think that you guys argued well, you prepared well. Just next time, just make it a point that you cover all bases. But congratulations on making it thus far to the competition. And yes, you guys did really well. I'm really proud, yes, of you guys. And yes, I think that now the session is dissolved and you guys may leave the meeting. Thank you.
Thank you for your feedback, Justices. We really appreciate it.
And then, do you have any feedback for us? How have you felt the session so far?
It was very challenging, but we enjoyed it, and it was a very interesting experience. I must say it was one of the best experiences in my life.
That's excellent. Excellent.
Thank you.
Okay, thank you so much.
Yes, I think that we have to send the score sheets to Joyce and then CC, Philip, and Simon.
Thank you, Shange. Yes, we'll do so. Thank you. I'm preparing mine as we speak.
Yes, thank you very much.
Thank you very much, and thank you for presiding.
Yes, have a good day.
Sure. Great. Was this our last session for today, at least?
Yes, yes.
Yes, I think so.
Okay, thank you very much. Thanks, colleagues, and
Thank you.
thanks.
Bye. Be well. Thank you.
Thank you kindly, Justices, and thank you very much for your patience. It's really appreciated.